Who filed this? Is this up today, Jennifer? This motion for discovery sanctions?
It is, Judge.
Yes,
When was it filed?
the 25th. Or no, I'm sorry, that was the response. The 20th, August 20th.
All right, Walter Lazinski and Noreen Lazinski versus Anthony Frank individually in doing business as AF Custom Concrete and A Custom Concrete LLC. I didn't get this. All right, what do you got, gentlemen? Your appearances?
Good morning, Your Honor. Eric Glick.
And this is 2504368. Good.
Yeah. Good morning, Judge. Eric Glick, appearing on behalf of the plaintiffs, Walter and Noreen Lazinski.
Bruce? Mr. Bruce, your name? Your appearance, Mr. Bruce? Mr. Bruce?
Sorry, I had to fix my volume.
Your name?
Ronald Bruce on behalf of Mr. Frank.
Jennifer, when is this trial scheduled for?
I believe September 22nd, Your Honor.
Yes, Your Honor.
I did not get this till this, it was laying on my desk. I didn't even think that this was up.
Your Honor, there's a lot of detail in here. Do you want to pass on this one until you've had an opportunity to review it, or? I mean, the problem is it's a discovery motion. We're a little bit under the gun here with the trial coming up in 3 weeks.
Can't believe, I know I shouldn't have adjourned it before. I should not have adjourned this trial before. You guys stipulated to adjourn it. I thought it was close to settling and I should never have adjourned it before. You tell me what you got here, counsel. I don't even remember what this case is about. Obviously, so why don't you start, Mr. Glick? I'll listen. I've got a busy day and I'll try to get through this, okay?
Sure. So, Your Honor, this is my clients contracted with the defendants to have the concrete work done, driveway, porch, patio. The driveway was done and it immediately started deteriorating, cracking, scaling, popping. You've probably seen these cases. The EPA changed the formulary on concrete, and when people weren't paying attention, concrete installers weren't paying attention, these driveways just fell apart. And that's what happened in this case. So for the following two or so years, my clients try to work with Mr. Frank, who would continue to make promises. Yeah, we got bad mix. We'll take care of it. We're trying to get the SRM company to give us new mix for free because it was bad, and we're going to take care of it. We're going to take care of it. Until finally they just said, go jump in the lake. We're not taking care of it. So this lawsuit ensued. So from the beginning, Your Honor, Mr. Bruce, has asked for courtesies. He asked for an extension to file an answer to the complaint, which we granted. We had a pretrial conference. The court ordered discovery, so we sent out discovery. Mr. Bruce didn't respond to those discovery requests. Under the court rules, we're to make efforts to try to resolve discovery disputes without involving the court. So we did that. Mr. Bruce signed a stipulated order, which the court entered, saying that they would provide full and complete responses to the discovery. And that's when this case the trial was adjourned because of that discovery failure and the promise to provide full and complete responses. And also because Mr. Bruce had made some overtures towards a settlement proposal. Well, now we received the discovery responses and they're nonsense.
Show me where they are on this in your brief here. You've got, what was the question in interrogatory 1?
It's exhibit number or exhibit letter. It's exhibit D to the brief, Your Honor. Their responses. They're not signed. Obviously, they were just.
Hold on. You said exhibit D.
Correct.
Right?
Yes.
All right, so tell me which ones are deficient.
Okay, well, first of all, obviously, these were just like provided to the client and say, here, fill these out, because there's handwritten answers, there's no signature on them. And on the first page, even when we're asking for people involved in this project, you can see names are cut off over in the margin. So I guess the answer to your question, Your Honor, is interrogatory number
Yeah.
one.
What are you guys doing? You can't just have them do that, Bruce. I mean, how's he supposed to read these? Something Anson, ad labor, 5 years experience, retired, it looks like. Stein Booth, EAD construction. I mean, is this the way lawyers are doing things these days? I haven't practiced in quite some time, but I wouldn't have done this when I was 24. What's going on with this?
Well, Judge, I didn't realize it was cut off. Obviously, we can provide more clear answers.
It left your office, Mr. Bruce, right? I mean, you sent it out. Did you even bother to look at these? I mean,
Well, I did. I didn't realize it was cut off, obviously.
well, am I crazy to think that, listen, I mean, how do you? You didn't do anything on these. Mr. Bruce.
What do you mean we didn't do anything? All of them are
This is
answered.
junk. This is junk. Covered liability and workers' comp. Did you provide them with the insurance company and policy numbers? You just said covered. What does that mean? Covered liability and workers' comp. He's entitled to have that information. Each subcontractor, their name, address, telephone number, contact person. Am I right? At least when I was practicing, believe it or not, it was a long time ago. Were you not required to put, has the rule changed? Are you not required to answer these in typewritten fashion after each question? Am I right or wrong? I'm asking either one of you. Do you want to enlighten me? I mean,
You're right, Your Honor. That's why we filed this motion. I mean, this is just the tip of the iceberg. This is question number one, and you can't read them. Plus, most of the parts aren't answered, and this is only the first question. There's, 12 more questions. And Your Honor, that's why we're here, because now there's 2 court orders that have been violated. There's the order allowing for discovery, the pretrial order. There's a stipulated order that they're going to provide full and complete responses. We get this garbage, and now we're prejudiced because we've got trial in 3 weeks. We finally got this information, which allowed us to subpoena records from SRM Concrete, but we have nothing else. So what are we to do? Are we going to be prejudiced going to trial with nothing? Or is the court going to have to adjourn this again? Or are we going to just enter judgment against them for failure to comply with discovery? That's what we're asking for.
Mr. Bruce.
Judge, my client did make a good faith effort to answer.
This is nonsense. This is garbage. This is garbage. You're going to force me to enter a judgment against your client because of non-compliance with an order of the court? This is nonsense.
You'd certainly oppose that.
I'm flabbergasted that you're trying to tell me that this is anywhere compliant with what needs to be provided. I'm just shocked. Is this a jury trial or a bench trial?
Bench.
Bench, Your Honor.
Mr. Bruce, I don't know what to say. You know, when I talk to lawyers off on other cases, they tell me this is the way things have gotten, and I refuse to believe it until I see nonsense like this. I don't know why lawyers do this to one another. It just gives them heartache. And it's not right. This is so ridiculous that you would submit these documents with printed words like this, half-hearted answers from a client and not provide full information. Now, I mean, I don't want to sit here and lecture you. You've been practicing a long time, I think, but this is ridiculous. You got to tell me why I shouldn't enter a judgment in on their behalf.
Judge, he did attempt to answer. The first page is the only page that's truly.
They could ask me what my name is, and I could write MI. Can I say I attempted to answer? Give me a break. This case is 307 days. You know, I love this. They tell us you got to have these done in so much time. Jennifer, what was told to you when I remember when I was reluctant to sign that order before about the adjourned trial date? What was told to you?
Your Honor, which started that they had requested a 60-day adjournment, and then after we spoke, they then sent the stip in for 30 days.
I wonder if they're going to have an asterisk when they put her name on here, tell me that I'm delayed. Are we going to have an asterisk said judge didn't cause any of this? It was the lawyer or the lawyers. Is there going to be is there part of that form that says that on there, Jennifer? I want to make sure. I want to make sure that when somebody's questioning what I've done and not done, that they know the judge had absolutely nothing to do with this. Here's the deal. You got 7 days to provide them with full and complete answers. 7 days from today's date. You're going to pay them $300 in costs and attorney fees. If the answers are not fully and completely answered, I'm going to default your clients. Period. I'm adjourning the trial date, which is scheduled for what, September 22?
Correct, Your Honor.
And it's 307 days old. We're adjourning it for another. I mean, it's not fair to the plaintiff. And I don't even want it to say 7 days. I want you to submit an order today, Mr. Glick, that says that the costs are assessed as I just indicated. Plaintiff's motion is granted to the extent that defendant shall provide full and complete answers to the interrogatories
And request
on or before September the 8th. Trial is adjourned from, you said the 22nd, Jen?
Yes, Your Honor.
Give me a date, late October, so I'll go on report it. That's okay.
October 20th, Your Honor,
October 20th at what time?
10:30.
And your clients better be ready, because if he wants their deps after this, they better be produced. You need any depositions, Mr. Glick?
Well, yes, I probably will. I mean,
I know, I just can't believe this. Do you know anybody that you want to depose right now that you haven't deposed yet?
well,
That's
probably,
a party of theirs.
well, it would be Mr. Frank. And
When do you want the
it looks like they're
deposition?
trying to accuse SRS Distribution or SRM Distribution, who supplied the concrete, of, someone over at their office. Not
When
quite
do you
clear
want
who that
Mr.
is yet.
Frank deposed? You tell me when you want to depose.
I'd have to schedule that, Your Honor, but I would say if they pay the $300 and if they provide full and complete responses that are satisfactory to this court, and I might want to even say, can we have a control date on this to make sure, so I don't have to file a third motion?
With you, we're setting a control date for the 15th. Am I here, Jennifer?
Yes, Your Honor, you're here.
All right, set a time for that. We'll make sure.
We
that
can
the
do
interrog-
8:30 because you have probation that day, so we'll do this before.
Fine, September 15th. Put all this right in the order, Mr. Glick.
Your Honor, I have,
If you can't do that, tell me, I'll give you a different time that day.
yes, any chance we could do afternoon that day? Because I have,
What do I have? That's state day, right, Lisa? I mean, Jennifer?
Yeah, I'm just looking to see if you have any carryover yet.
I'm in Oakland County Circuit Court that morning.
You do have carryover starting at 1 o'clock. You have some sentencings. So you do have an afternoon docket that day.
12:45. September 15th at 12:45. Parties can appear by Zoom. So do you have everything that you need for the order, Mr. Glick, that you want right now?
Your Honor, there was also a request for documents that we'd like them to respond to, not just the interrogatories. So I would put that in order. $300 cost that they'll pay those, and if they don't pay that also by September 8th, then default would be entered.
Yes. And I'm going to order that any and all documentation, what can I look at the request for production of documents? Is it in here somewhere?
Yes, it's also part of that Exhibit D. There were things referenced like emails. They haven't provided really much of any documents. There's no order information or delivery information for the concrete. There's no licensing. There's no insurance. There's no permits. They really didn't provide anything except maybe, I think, 2 pictures and something else. I'm sorry, 5.
Hang on a second. Let's do this. I mean, if they don't have any, they can't produce them, right? You agree with that? And they're saying
Your Honor.
none.
Right,
It
but if
looks
you
like
look
they're to answer, provide responses to, amended responses to.
Your Honor,
I didn't realize you were there, Mr. Frank. Your name?
yeah, Anthony Frank, I just feel the need to interject if I and say you're exactly right.
You're cutting out,
business.
sir. Hang on a second.
These
Hang on.
records, these
Hang on. You're cutting out.
Yeah.
Completely cutting out. I can't hear a word you're saying.
okay.
Why don't you try again?
How about now, Your Honor? Any better?
Yeah, that's better.
Is that any better, Your Honor?
Yeah,
Okay,
that's good.
You struck a point. You struck a point that's exactly on here. We're a very small business. Until about 2020, I also worked at the nuclear power plant and did this as moonlighting. We've only recently gone full time. These questions that they're asking, how many driveways did you pour 10 years ago? How much did you make 10? These are, unless you want me to fabricate something, I don't have these documents. I don't have this. We don't have those records. We're just now getting LLC 2 years ago, and now we have a tax person. We're getting our books right. We're getting our documents, our records right. But these things he's asking for, I cannot produce, and that's why I put NA, not available. That's the truth. They're not available.
Well,
I can't.
I just got done saying.
So you're going to send out the discovery again, hoping for full and complete answers that I cannot provide you.
Second, Mr. Frank. First of all, you got a lawyer here. Okay. Second of all, if there's nothing there, but what in the world is this? Produce all records identifying weather conditions on the date of an email to Bruce, including internal records, logs, reports, or weather-related notes. I mean, they did answer these. Which ones do you want them to answer, Mr. Glick? They're saying there's none.
Right. If you look at some of the interrogatory responses, and I can go through there, it says
I'm with you on the interrogatories. I'm talking about the request to produce.
Yeah, no, what I'm saying is one of the requests to produce is produce documents identified in your responses to interrogatories. And they reference things like documentation between us and the concrete supplier, but then they haven't produced those. Now, if they want to say, okay, we don't have any permits for this, we don't have a license, we don't have insurance, then great. Hopefully when we go to trial and they try to show something like they were licensed or insured, then the court will say, hey, you were asked to provide these things, you said they didn't exist. I don't know what they're saying. Are they saying they don't have them? They don't exist? I don't know. But hey, you're right. Absolutely right. If they don't have something, they can't produce it. I get that.
Do you understand that, Mr. Now it looks like they're saying none to everything. I don't know what this means. Somebody wrote plaintiffs after number 1 and 2, and somebody wrote email to Bruce after 5 and 6, and after 17. Those responses need to be amended. You're to respond to those specific ones. 1, 2, 5, 6. Excuse me. Yeah, 1, 2, 5, 6, and 17. File amended responses to those by the 8th. Okay?
Yeah.
I don't know what else I could do, Mr. Glick. If they're answering none, they're answering none. And you're exactly right. We go to trial. None of that's coming in if they try to introduce anything and they haven't provided it to you. You're absolutely correct on that. Is there anything else I need to cover? So you're going to include all that in the order, right, Mr. Glick?
Yes, Your Honor. I'll do my best.
They're to file amended responses to the request to produce numbers 1, 2, 5, 6, and 17. To provide amended responses to all interrogatories. Complete answers to interrogatories on or before September the 8th. Costs are assessed. I said 300 or 350? 300, right?
Yes, that's
Costs are assessed in the amount of $300. We're gonna have a hearing date to determine the propriety of the answers and responses to requests for production of documents on September 15th at 12:45. And trial is adjourned until October, what'd you say again, Jennifer?
October 20th at 10:30.
At 10:30.
Your Honor, would the control date on September 15th be in person or by Zoom?
We can do it by Zoom, and you can put that right in the order. But Mr. Frank, you first of all, guys, this printed stuff, I would think that you'd put them in typewritten form, and then we don't have to worry about things getting cut off on the side of the pages. All right, that's what I'm doing. Have a good day. Submit your order. Jennifer, write all that down on that packet for me, will you please?
Yes, Your Honor.
Here you go, sweetie. Thank you very much. Have a good day, gentlemen.
Thank you.
Judge, thank you.
People against Capital One versus Dolores I. Dalrymple, 2602922.
Good morning, Your Honor. Thomas Ducat, P82958 on behalf of plaintiff.
Good morning, Mr. Duquette. Do I have anybody here for the defendant?
No, Your Honor.
There is counsel on this one, Your Honor, and he actually just emailed us. He's in one of the Grand Rapids courts right now, so I assume that he is just tied up. This is just the first pretrial, I believe. So I think all we'd be looking for today is a scheduling order.
I'm not going to get into setting pretrial dates without both lawyers here. Tell him he's going to have to appear, Mr. Duquette, and I'll be glad to give you dates. Do you have his phone number? Just text him. Judge is requiring him to appear. Is he appear in Grand Rapids in person, by Zoom?
I can't quite tell that from his email. He just said he's finishing up in a Grand Rapids court, but I will certainly.
Well, I'll recall it then. I'll recall it.
Okay.
Recall it. Cinnamon Warren versus Concord Co-op. 2603429.
Yeah.
Good morning.
Oh, we have to be you.
Your name?
My name is Carol Purdy.
Can you spell your last name?
URDY.
Is in your Concord.
I am. I'm the treasurer on the board of directors.
What happened with Miss Cinnamon Warren? Is she here, Jen?
She's not sure.
Yeah, she's not checked in yet, Your Honor. This was a 9 o'clock.
What's that line? I wait for the future. They file an action and they don't show up on time. I'm waiting about 5 minutes, and if she doesn't show up, I'm gonna dismiss it. You can have a seat, okay? Boy, oh boy.
Supposed to be 30 something here. Should have a bigger one.
I only have Wuzinski, Capital One versus Dalrymple, and Cinnamon versus
Should
Con.
have Michelle Mahalik and then Citizen Bank.
Do you have those?
Everything up there.
Those all the 30s I gave after before.
Anything else? Those are the three that I had. I'm sorry. Unless I put them under here, my apologies. Capital One versus Charlo. Capital One versus Kayla M. Charlo, 2602608. All right, Mr. Duquette, your appearance.
Good morning again, Your Honor. Thomas Duquette, P 82958 on behalf of plaintiff.
Get some pre-trial orders for me.
And
Is
Your Honor,
Kayla
defendant did not check in with the court.
I'm gonna need some. You can go ahead and take a default if you want. This is scheduled for 8:30.
That is what we would ask for, Your Honor. Based on the failure to appear, the total judgment amount here would be $1,933.56.
Does that include everything?
Yes,
I'm gonna need a breakdown.
sure. Damages are $1,801.04. Court costs are $132.52.
For a total of 1933.
$1,933.56. Yes.
Right. Okay. Default judgment. Defendant failed to appear. Case was scheduled for 8:30. It is now 9:15. Default judgment will enter in favor of the plaintiff against defendant Capital One versus Michelle Mahalik. This is 2602799. Is Ms. Mahalik here? You have
Your Honor, I believe she was and spoke with Mr. Groen, but I no longer have her in Zoom.
Mr. Groen, did your name?
Yeah, good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff. I did speak with Ms. Mahalik. She just made a lump sum payment on this, so we're looking just for a short adjournment for those funds to clear, and then we're going to be, she gave me authorization to sign a step-in order for dismissal with prejudice. So we just need to kick this out just a little bit for those funds to clear, and we'll get this one put to bed.
Okay. We'll adjourn 3 weeks, okay?
That will work.
Adjourn 3 weeks and parties will submit stip in order to dismiss, assuming funds clear, okay?
And we can, Your Honor, we can do that September 22nd at 8:30.
9/22 at 8:30.
Thank you, Jen.
No
All right,
problem.
do you have any others?
I have the Citizens Bank Springer.
What time's that up?
8:30,
That was
Your Honor.
8:30 as well.
Oh, Citizens Bank versus Emil Springer, 2602882.
Once again, Your Honor, Brian Gruen, GROEN, P number 56673 on behalf of plaintiff.
Do you have some pre-trial orders?
I don't. I gave you, I think, like 20 of them.
Oh. Okay. All right. Ms. Springer, your name, ma'am? Mr. Springer, I'm sorry, sir.
I'm Emil Springer, and you're okay, Your Honor.
My apologies.
It's okay.
So did you two talk, Mr. Groen, your appearance again?
Once again, Your Honor, Brian Gruen, GROEN, P number 56673 on behalf of plaintiff. And we did speak. Mr. Springer actually called our office yesterday, worked out a payment plan. We just need to get the consent judgment out to him so he can review and sign. So once again, we're just looking for a control date Do you want to do that 3-week date on this one as well?
Fine
That will
with
work.
me. September 22, at what time did you say again, Jen? 8:30?
8:30.
Adjourn to September 22nd at 8:30, tentative agreement. Good enough. You guys
Thank
have
you,
a great day.
Give a
Thank
better
you
week
both.
with you.
Have a good day.
Your Honor, both attorneys are present on the Capital One now.
Capital One versus Mishalik? No.
Delbert.
Which one is it again?
Delbert.
Capital One versus Dolores I. Dalrymple, 2602922. Okay. Your appearances, gentlemen, please.
Good morning, Your Honor. Thomas Duquette, P82958 on behalf of plaintiff.
I'm
And good morning, Your
sorry.
Honor.
Give me, hang on one second. Give me your appearance again, Mr. Duquette. I mean, your P number.
82958.
Ooh, I wish for the days. Go, Mr. Stratton.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the defendant, and apologies for my tardiness. I was wrapping up another case.
That's all right. You guys, you need discovery?
Yeah, if we could get a period of 60 days, I think that'd be good.
I'll give you
And I
until
concur.
November 1. Witness lists are due October 1. Nobody demanded a jury trial here, right?
Right.
Correct.
I'm going to just put down 1/2 hour for trial. We're not going to have a settlement conference. Give me a trial date momentarily, Jennifer. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. And that is about it. Let me see. I'll give you November 1, October 1, witnesses due, 1/2 hour for trial. All motions for summary have to be filed and heard not later than 1 day before, not later than 20 days before the trial date. I'm sorry. What do you have for a trial date, John?
Your Honor, that would be January 25th
Oh, we want to go all
at
that way?
10:30. I'm sorry?
You don't want to do December?
You gave discovery cutoff of December 1st?
No, November 1st.
Oh, November 1st. I apologize. I
That's
heard
okay.
December. Then let's do December 29th at 10:30.
Well, let's do it. Let's move it back a week or so. How's that?
A week or so? Okay.
The 22nd,
15th.
15th. 15th at 10:30, December 15th at 10:30. We'll send this out for you guys, okay?
Sounds
Thank
good.
you, Judge.
Anything else, gentlemen?
No, that's all.
That'll
Have a
do it.
great day. Thank you both. Here
Yep,
go.
you too.
See. Who you two have in the bag?
They're 9:30.
All right, Cinnamon Warren versus Concord Co-op. 2603429. Your name?
URDY.
Are you new over there?
No, I've actually lived there for 33 years and about 4 years on the board of doctors.
Okay, so you're on the board, but you're not the property manager.
No, he's on vacation. No, that's all.
All right.
I'm the treasurer, so they sent me to do stuff like this.
Your Honor, just so you know, we did try reaching out to the plaintiff on the phone number that she's provided, and it does not accept calls right now.
Dismiss the case. She was given 15 minutes. The case was scheduled for 9. It's now 9:22. Case dismissed. They're gonna probably file a motion to reinstate it, but
Okay,
okay.
I'll have everything ready.
Have a
Thank
good
you.
day. Thank
You as
you.
well.
All right. Hayes. John Daniel Hayes, 24G 707-335.
I did not.
All right. Everybody's name, please. Where's the defendant at? I mean, the defense lawyer.
Your Honor, can you hear us?
Yeah, I can hear you. We need to wait for the defense lawyer, though, okay?
I heard him say stand up. Yeah, there's something wrong with our system here.
I'm gonna have to have you hold that too, but.
There we go.
Well, not that,
I have the other stuff.
the motion.
Yeah.
Okay, good enough. Who's the defense lawyer?
He's coming in now.
People against John Daniel Hayes, 24G 707-335. All right, Mr. Hayes, your name?
John Hayes, sir.
Mr. Crawford,
Michael Crawford, representing Mr. Hayes.
detective?
Detective Sergeant Gary Robinson, Gibraltar Police Department.
All right, so we have count one, operating while intoxicated, high BAC, third offense. Count two, operating while intoxicated, third offense. There's also a second offense notice. So he was convicted of at least three priors, at least three other OWI or operating while impaired charges. How does he wish to proceed for purposes of a ring?
Your Honor, I'd like to stand and wait formal reading of the charges.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to be represented by a lawyer today. You have the right to be represented by your lawyer at all subsequent court proceedings. You have the right to be represented by a lawyer if you choose to submit to questioning with law enforcement officials. You have the right to a probable cause conference within 14 days. The probable cause conference, your lawyer will discuss the case with the prosecutor. If it proceeds to a preliminary examination, at that time, the people have to show that the crime was committed of operating while intoxicated, high BAC, third offense, and also OWI, third offense. And if they prove that, you'll be bound over for further proceedings to the Wayne County Circuit Court. That is, if they prove probable cause to believe the crime was committed and that you were the one who committed it. Otherwise, the charge would be dismissed. Do you understand that?
Yes, sir.
All right, probable cause conference, September 15th at 9:15. You'll be in front of Judge Hesson. Preliminary exam, September 22nd at 11:30 a.m. You'll be in front of Judge Hesson. I'll listen to anything you have to say regarding bond.
Your Honor, my client's requesting personal bond. He lost his wife just here in the past couple of months, Your Honor. So he's a single dad. He's got a child at home who needs to finish getting enrolled. School's supposed to start this Thursday. He's the sole provider, obviously, for the household. He's working. He works at Asteroids Industrial over in Harrison Township, Your Honor. So he's not flight risk. He's got someone who can drive him. He's getting back and forth to work, his son, school, family member. So he's looking forward to considering personal bond, Your Honor, so he can continue to take care of business and make sure he returns to court with all this.
How many priors does he have, Detective?
Your Honor, I don't have the CCH in front of me right now.
He's got at least three. What was the blood draw on this?
221.
Where do you live, Mr. Hayes?
Harrison Township, sir.
What is your address?
36530 Jefferson Avenue, Block 95, Harrison Township, Michigan, 48045.
Warrant was signed in 24. Did the department notify him of his warrant that he had outstanding?
I don't have anything in the supplements that say that he was called. Typically, we mail something out.
There's nothing in the file to say that my client was notified. My client was unaware of this. He found out when he got picked up. Yesterday was the first he heard of it. He thought this matter had been.
Just they threw it in the garbage? He was arrested, right?
He was, but the prosecution decided.
Where does he work?
Again, he works at Asteroid Industrial in Harrison Township.
How much does he make?
Your Honor, he's not a man of means. He makes about $17 an hour. He has to take care of his son and household.
They are doing that now, at least notifying and telling and making notes as to whether or not they've notified people, right, Detective? I mean, that's a
Yeah, sure.
weird.
I attempt to call and then we mail a letter saying, hey, you have a warrant at 33rd District Court.
Yeah, I'm troubled that this was outstanding for 2.5 years.
It's my client's trouble too. He would have came in and dealt with it. He didn't know. It's a complete surprise.
30,000, 10%. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. You must appear in court as direct, no alcohol, no marijuana, no illegal drugs. You're to attend NA at least 3 times per week. You're not to be released until fitted with a sober link device. Even if you post your bond, you're going to be taken to the county. You're not to be released until fitted with a sober link device. Okay, so hopefully you can post that bond and they'll be able to fit you with a sober link device ASAP. All right. You understand your court date is September 15th at 9:15, correct?
Yes, sir.
So you're gonna have to post $3,000. Good luck to you. We'll see you back here. Thank you. Thank you, Mr. Crawford.
Thank you, sir.
Inland Credit versus Katie Salmon.
Your Honor, if we
Choose-
could, the parties are in a breakout room right now.
Okay. Is Misty and Irving Struck versus Dale Meserant? Are they here?
Right to the podium.
Are the other parties here?
Yes.
Right to the podium.
You're both here?
Yes, yes.
Okay.
Right to the podium. This podium right here.
All right. Good morning. Everybody's name, please.
Misty Strack.
Okay. Just give me 1 second.
Yeah, right here. Right here.
So it's Strack, STRACK.
Yes.
Sir, your name?
Dale Meserant.
And what's your name, ma'am?
Sherry Edwards, Miss Potter.
All right. Says you sold Misty / Irving Stack, Misty and Irving Stack, I guess, a boat. You said it had no issues, ran great, paid $5,500 for. Cost us $905 to have it fixed properly. Give somebody here that's going to tell me that the nature of, now I want to be clear about this. Listen to me very carefully. You're going to have to prove fraud. You're going to have to prove that he knew of the condition. You don't own a boat shop, right?
No.
You just sold this
Right.
as a personal owner, correct?
Yeah.
You're going to have to prove that he knew there was a problem at the time that he sold it.
What he said that they.
I'm not done. So if you think that you can, I don't know the nature of the problem. I don't want to know the nature of the problem right now. I just want you to know, you're gonna really have to almost bring in somebody who's a boat mechanic that can tell me, yes, this happened. You guys aren't gonna let me finish. Just let me finish, okay? You're shaking your head. You have what?
I get the okay to take the boat to the shop being fixed and got the receipts to the people that did do it. If he said it ran properly, there was no issues for
Ma'am, okay, are you gonna let me finish though, please? I'm just saying. Do you have the mechanic ready to go on Zoom and to tell me that, yes, the nature of this problem was such that the defendant, just please listen. I'm just trying to give you a heads up here. I'm not trying to argue with anybody. You're going to have to prove that the nature of the problem was such that this man knew at the time that he sold it. You could buy a used car and the owner not know there's a problem with it, and all of a sudden you go out and you find out there is a problem. I don't know how close in time it happened. I'm just offering you the opportunity to get the mechanic in here. That's all. Before we go on.
He's willing to do that as well.
Can you get him on Zoom?
We have to call the boat shop that fixed it.
We'll do that right now. Why don't you go out in the hallway? Take your phones out in the hallway. You can't use them in here. And go call and see if he's available right now. And then if he is available right now, we're going to proceed now. If not, I'll let you adjourn it and go get him. You can subpoena him. Okay, so go ahead and call him. So you guys can have a seat. I'll be back in 5 minutes. Up. Stay seated. Hey, take your head off, sir. Recalling Strack and Mazarin. 2603325. Your name?
Misty Strack.
Your name? Strack. Sir, your name again?
Dale Manfra.
Ms. Edwards, your name?
Sherry Edwards.
Did you get a hold of him?
I did, and they're extremely busy right now. He said they never had to do this before, but he has no problem being subpoenaed in, or asked me if I had the receipt. I said yes. He said that should do, but if not, I can be subpoenaed. That they cannot be zoomed in.
You've never had to do this before. That should do. What is he, a lawyer? Did he go to law school?
That's just what they.
I just want to know if he went to law school. Did he go to law
They
school?
never had to do Zoom.
Okay, well, that's fair, but everybody knows everything about everything, don't they? I'll give you an adjournment. You can subpoena him. Now, before we go on, I want everybody to understand something. If you proceed in the small claims division, you're giving up certain rights. You're giving up the right to hire a lawyer. You're giving up the right to appeal my decision. You're giving up the right to seek in excess of $7,000 if you're the plaintiff. And you're giving up the right to demand a jury trial. You don't have to give up those rights. If you choose to, you can have the case removed to the General Civil Division. I'll still be the presiding judge, but then you can hire a lawyer if you want. You can have a jury trial if you want. You can appeal my decision if you want. And to the extent that you might be entitled to it, you are entitled to collect or seek in excess of $7,000. Do you understand everything I just said, Mr. Strack? Yes. Ms. Strack? Mr. Mazarin? Yes?
Yeah.
Do you wish to give up those rights and proceed here or have the case removed? Mr. Strack? Here?
Yes.
You waive those rights?
Yes.
Ma'am?
Yes.
You waive those rights?
Yes.
Mr. Mazarin?
Yeah.
You waive those rights?
Yeah.
Good enough. I'll make a note. Rights waived, case will remain. Now, if he doesn't want to appear by Zoom, he's free to come in here. Where's his shop at? Well, I'm just trying to make it more convenient. If he'd rather come here, he's free to. Okay, so let me be clear about that. But you should subpoena him.
Trying to get on Zoom, he said, I said, well, if you can't do Zoom, then I guess I have to subpoena you. He said,
Well, either way, you should subpoena him. Either you can get on Zoom or not.
Right.
So let's adjourn it out 3 weeks, Jennifer.
That would be the 22nd.
September 22nd.
Let's do, we have quite a few small claims that day already, Your Honor. Let's do 9:30.
9:30. Okay.
angry.
They'll explain to you how to get the subpoena served and how to fill it out. They'll issue it down the hall. Okay? Thank you. Have a good day. We'll see you back here on the 22nd. Midland Credit versus Stanley. Did I call that one?
No.
Yeah. Katie Stanley, 2602795. Ms. Stanley, your name?
Hi, good afternoon. Good morning, Your Honor. My name is Katie Stanley.
Mr. Hill?
Morning, Your Honor. William Hill, P 28608, appearing on behalf of Midland Credit.
Do you wish to, did you guys talk and resolve this? Ms. Stanley, you have to start your video, ma'am. I can't just see a picture of you, please.
Oh, I'm sorry, sir.
That's okay.
Give me 1 second here.
There you go.
Oh.
You're on.
Does it work?
You're on. You're good. You're good.
Oh,
Did you
okay.
guys, you resolve this, Mr. Hill?
No, Your Honor, we have not. We're going to need some time for discovery on this. If you could give us perhaps 60 days and perhaps set another pretrial. We are at an impasse today in terms of resolution.
Okay. All right. Do you owe this debt, ma'am?
So, Your Honor, I do I do want to acknowledge the account, but I do not agree with the amount that is owed.
How much do you owe?
The plaintiff's attorney is saying I owed Midland Credit a little over $1,300. So I did try to settle the debt today for $450, which is what I can realistic.
How much do you owe, though? Do you owe what he's claiming that you owe?
No, I don't agree with what.
How much do you owe? I'm asking you how much you owe.
Apparently $1,300.
So you agree with what he says that you owe?
No, I do not agree with what.
Ma'am,
he's
I'm
saying
asking you how much you think you owe.
I think that I owe what the original debt and amount is, which I am not exactly 100% sure what that is. The original balance, whatever that pertains to.
So you don't, okay, listen. I'm gonna give you your free trial.
Okay.
But just keep in mind that the thing about math is you can figure out exactly what you owe, and it doesn't sound like you know what that is. And if you don't know what that is, I don't know how you can dispute what he claims you owe. So I'm gonna give you I'm gonna give you a trial date, but keep in mind they're entitled to interest. I don't know what figure they gave you total, but that's quite a disparity between 1,200 and some and 400 and some, right?
Yes, sir.
So I'd suggest that you go back and figure out how much exactly that you owe, okay?
Absolutely, sir.
All right, so we're gonna give you a trial date Witness lists are due on October 1 of 26. Discovery, if you want, if they have something that you think will help show that you don't know what they say you owe. Interrogatories request to produce November 1 of 26. Discovery is, you have to be done with. No motions date of trial. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. Trial date will be on October. Would you give me, or I'm sorry, Jennifer, what day again?
December 15th at 10:30.
December the 15th at 10:30. Okay. Now, because you can't afford something doesn't mean that you can't work out a payment,
Yes.
for whatever amount you guys agree upon. And if you can't, if Mr. Hill doesn't think you're paying enough, you could file a motion for installment payment orders once a judgment's entered, and I'll decide how much you can afford based on your income. Here you go. Based on your income and everything else. Okay.
Okay, yes, Your Honor McNally, thank you.
All right. Have a great day. Good luck. Thank you both. I'll just make a note, pre-trial held, and hopefully you'll continue to talk. Best of luck to you.
Okay, have a wonderful day, sir.
You too. Thank you.
Thank you.
Brittany Olmsted versus American Avenue, 260200.
Good morning, Adam.
Good morning to you. Do I have anybody from American Avenue here, Jennifer? I don't know.
Huh?
Jennifer,
Yes, Your Honor, sorry.
has anybody shown up on this American Avenue?
I have not had anyone check in. It looks like it was, did I print the proof for you, Your Honor? Excuse me.
Yeah, that's, well, I mean, I got a big packet here. My God. There's got to be 100 pages here.
Yeah, that was the plaintiff's filings. It was served by certified mail.
Are you listing them in San Francisco?
Their property management company. That's the address that they gave me to mail that.
But they're on George Street in Trenton?
That's the home that I rented, yes.
That's the what?
That's the home that I rented.
Do I have proof of service here, Jen?
Your Honor, all I have is a certified tracking. I can share my screen really quick. Okay. Are you able to see that, Your Honor?
I am. Do you have a phone number for them?
I do not. Unfortunately, the only way I'm able to reach them is through email.
Well, it looks like a signature. I mean, I can't make it out. It's worse than my signature, but does look like they have one. Do you agree with me?
Yes, Your Honor. It does look like a signature of some sort. I agree.
Well, I want you to understand what I'm going to do is I'm going to take a default here. Can you send down a default judgment, please? Or is there one attached? I don't, oh, yes, there is.
Yes, I did a paperclip it to the back.
Good. All right. Raise your right hand, ma'am. You solemnly swear affirm under penalties of perjury that the testimony you give in these proceedings will be the whole true self you got.
I do.
All right, well, this isn't scheduled for 10 until 10. So I can't really, I give everybody 15 minutes. Which law school? You should go to law school, maybe. Did you do all this research yourself?
I do, yes.
Well, okay, just give me about 15 minutes. I'm gonna give them till about 15 after, a little bit, couple of minutes after that. And if they're not here, well, you're gonna win. Capital One versus Ronald C. Denman Jr., 2602673.
Your Honor, I have defendant here. Plaintiff's attorney has not checked in yet.
Is that Mr. Duquette again?
It is Mr. Duquette. So I was going to reach out to him if he wasn't here in a few minutes, because I'm not sure if he realized he had a 10 o'clock.
All right, why don't you give him a call? I'll get off the bench. We'll go from there. Thanks. Everybody stay seated. And you would be paying
damages.
Capital
No
One
one on
versus
Zoom, Your Honor.
Denman. Capital One versus Denman, 2602673. Mr. Denman, your name?
Hi, I'm Ronald C. Denman, Jr.
Mr. Cates?
Good morning, Your Honor. Andrew Cates, P78292 for Capital One.
Did you two talk and resolve this?
We did, Your Honor. We've agreed to a consent judgment. The plaintiff is requesting $8,818.27 in damages, $75 filing fee, $66.87 in service fees, for a total paid for of $8,960.14. The defendants have agreed to pay this amount in installment payments on the first and the third week of the month, starting next month, and those installments will be at $187 each until paid.
Well, how are you wording that? You're saying $187 bi-weekly, beginning on the first
Yeah, that would be how it would be worded. It's
is that what you want, Mr. Denman? So you understand you're going to essentially be paying on week 1.
No witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond reasonable doubt, in addition to all allegations in the indictment, that on or about April 13th of 2026 in Deerfield Township, Warren County, Ohio, the defendant, Tia Wesley, possessed methamphetamine as well as a glass pipe with residue.
Anything on those facts, Mr. Gibbs?
Nothing further, Your Honor.
Ms. Wesley, did you hear those facts?
Yes.
Do you admit that they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Yes.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction, or that these proceedings be stayed for a period of 3 years. I'm going to adopt a treatment plan, which is basically keep on the path of your current treatment. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. And you're not to have any contact with Mr. Turner. Anything else we need to do? Anything I forgot?
There you are. Thank you.
I would just note, Your Honor, I believe that she has 30 days jail time credit for this matter.
Yes, 30 days jail time credit. Hopefully that'll never matter.
Yes, sir.
Okay. All right. Good luck to you, Ms. Wesley.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Week 3, week 5, week 7, week 9. It's not gonna be just twice a month.
Yes, sir.
Do you agree to that?
Yes.
Do you agree to a judgment in favor of the plaintiff and against yourself in the amount of $8,960.14, with a further understanding you'll pay $187 bi-weekly, and we'd start that beginning what, October the 2nd, counsel? Is that right?
We could start at that date. That would be fine, Your Honor.
Is that good with you, Mr. Denman?
Yes, sir.
And then bi-weekly, so every other Friday you're going to pay $187, correct?
Yes, sir.
That means, I just want to cover this because it was weird the way it was worded. You said the first and third week. If we do this, that means you're going to have to pay on the 2nd, the 16th, the 30th, and then you would be paying, let's see, the 13th, the 27th. Do you understand that?
Yes, sir.
Do you agree to those terms?
Yes, sir.
All right. So you understand, as long as you make those installment payments as agreed upon, nobody can garnish your wages. They could still garnish tax returns, bank accounts, but they cannot garnish wages. Do you understand that?
Yes, sir.
Does Mr. Cates have your permission to sign your name to a proposed consent judgment?
Yes, sir.
All right. So, Mr. Cates, why don't you send that over? And you're all set. Any questions, Mr. Denman?
Will I be getting a copy of that, sir?
Yeah, as soon as we sign it, we're going to send it out. As soon as he sends it to me, I'll try to sign it the next day or so, and then you should have it by the 1st of next week.
Thank you, sir.
Have a great day. Good luck.
Thank you.
Thank you,
Thanks,
everyone.
Mr. Gates.
Have a good
Brittany
morning.
Faye Olmsted versus American Avenue, 2602020. Is anybody here for American Avenue, Jennifer?
No, Your Honor.
All right. Well, it certainly appears to me as though there was service. Ma'am, your name?
Brittany Faye Olmsted.
All right. Certainly appears to me that there was service. Nobody asked me for an adjournment. I would have given them one. It's 7 o'clock in the morning, 7:25 now in California. You filed a claim. Raise your right hand. You solemnly swear or affirm my penalties urge the testimony of these proceedings will be the whole true self you got. So they withheld the $1,700 security deposit, right?
Yeah.
What's the $49.56.91 you said in bad faith fees?
Those are fees that they charged me for early termination, and because of the sewage backup in the basement, they charged me for the.
Well, I'm not going to get into that. You know what? They didn't show up, so they're losing. $66.56.91. You have a filing fee of how much, Jen? 70?
Yes, Your Honor.
And what other costs do we have here? Filing fee,
There was
service fee?
service fees of $60 because of the size it had to.
So is that true? You have $130 in court costs?
Yes, sir.
I'm going to go ahead and add that in. Now, don't be shocked if they file a motion to set aside the default judgment. That just happens, you know. I'll deal with that as it comes. $6,786.91. I'm giving you a judgment. You can go down the hall, receive a copy of that judgment. You might want to talk to a lawyer about how to go about collecting. I don't think they're going to just drop a dime on their house, if you know what I'm saying. Right? Who are these good-looking kids? How old are you, Parker? London, how old are you? All right. Where do they go to school?
Parker goes to Gate and London goes to the Word.
All right. Well, have a great school year, you guys. Go study hard. Take care. Thanks. Thanks a lot. Good luck. All right. Now I have here Sean Reed versus David Stark, 2603066. Is Mr. Stark here?
Your Honor, he's not checked in yet. It is a few minutes early yet.
All right, ma'am, I have to give him 15 minutes, so if you could just have a seat, I'll be right with you. Is, by chance, is Glister or Magalonis in here? What's your name? And is Mikala Magalonis on, either here in person or on Zoom?
Not yet, Your Honor.
John Reed versus David Stark, 2603066. Mr. Stark, I see you going at the gum there pretty good. I'm gonna ask you to throw it. It's all right, I'm gonna ask you to throw it in the garbage. What is this here?
Yeah.
What are we doing? We're back here on another case, you two? Were you in front of me before?
Yes, sir.
You like me? What's your name?
Sean Mary Reed.
What's your name?
David Stark.
Why are you guys back here?
I had to talk to my lawyer for my other court case.
You're seeking $100?
Yeah.
For what?
He agreed to help me take the rods out of the ground from a survey. And I want to use my survey that was, I have it here.
Wait a second. You guys want to go talk about this? This is over $100. Are you guys friends or former partners or what?
I actually talked to him and I have nothing against him. And we could definitely work it out.
You want to go work it out? It's only over $100.
You want to work it out, Dave?
Sure.
Okay.
Sure. Thank you. So you want to give them each 50? All right, have a good, let me know when you're ready, okay? Thank you.
My understanding from my client.
He's got one right.
So it's a relative thing.
You like it? You like it not like that?
Right, not to be cold.
Yeah.
Stacy.
Fourth back session.
Did you call on those, John?
Yeah. Just waiting for Brownstown.
Okay. Do you have something ready yet or not?
Yeah, he's got one right. He's got one right.
And then you called on the other one?
I call Brownstown.
All right, let's take that real quick then. No. Ms. Magalonis, just bear with me for a second, will you please?
Yes, Your Honor.
People against Epperson. Tiffany Janelle Epperson. 25W8395557 A and B. And I also have 25W8410898 and B.
Good morning, Your Honor. Michael Crawford, representing Jefferson. Ma'am, state your name for the record.
Tiffany Everson.
She's another one. Huh? What's she doing on the suspend from 2025? She's standing mute, waiving formal reading?
Yes, Your Honor.
What is she doing on the other cases? I hope she's got some money with her today. And what's she doing on the 1089A? She's standing mute, waiving formal reading?
Yes.
So she's entering not guilty pleas on everything?
Yes, Your Honor.
I'm gonna have to come back and set a bond here. Where you been, man?
I'm at home, basically.
Well, you're supposed to be here and you only live in Detroit. I mean, come on. I hope she's got some money to post bond, counsel.
My understanding is my client does have some money. She intended to put it towards the civil capital. But she, I feel like you don't want to get your child.
Well, where have you been?
Oh, I lost my car shortly after all of that stuff happened as well out here on my time. I haven't been able to get out here, and then the flood things aren't Zoom, so it's not easy for me to come back. I can finally got a ride today.
You what?
Just finally got a ride today.
All right, stands mute, waves ready. Yes, you. How much might this she get?
I have enough to pay the ticket for the 500 and
So how much you asked that number?
for $500.
He's got 500.
Listen carefully, can you have, well, I'm gonna, on Epperson, listen, on file 89B, I'm gonna reduce it to 175, the balance is waived. On the no proof for insurance, your fines are reduced to $225 plus clearance fee. So I'll save the 57 bucks there of 45 for 280. Balance waived. So that right there is 225 plus 175 is 400. You pay $100 bond on the suspend charge. You're making this stuff worse than it is. You know that, right? Ma'am?
Yes, I discovered.
I'm sorry?
Yes, I've discovered that.
$100 cash bond on 25W8410898. And I'll incorporate the other two, C 25W8410898. 5W84. All right, so $100 cash bond on those. You're gonna come back, I can either have her back tomorrow or I can have her back, on the 16th. What does she want?
Your Honor, the main issue that she's asking the court is if she get allowed to appear by Zoom.
She can do that. I'll let her do that. She can appear by Zoom.
You can appear tomorrow, Your Honor, via Zoom.
All right, so we're gonna make it 9/2 at 9:15, okay, ma'am? And you can appear by Zoom if you want. You understand I'm letting you do that. They'll give all that information to you down the hall, okay? Just make sure you're on there and you know how to Zoom, right? All right, stop doing this in other courts. Good luck. You got another one, Mr.? You got another one, Mr.?
I'm still waiting up for us.
Magalonis, Robert Glista. McCullough Magalonis versus Robert Glista, 2603398. Soon, what, you're not going anywhere, right?
No, sir.
All right. Come on up here, folks. Your name, sir? Your name, ma'am?
There's filling in from the prosecutor's office. We are here today for a pretrial, but it's my understanding Mr. Ford's going to enter a plea of guilty to one count of assault, and that there is a joint recommended sentence of 9 months consecutive to the time that he's already doing. Is that accurately stated?
Yes, Your Honor.
Yes, Judge.
Mr. Ford, how old are you?
23,
How far did you go in school?
12th grade.
Are you able to read and write English?
Sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
No, sir.
Other than this 9-month sentence, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It's like on the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Bogan before you signed it?
Yes, sir.
Are you satisfied with the representation that you have received in the case?
Yes, sir.
You're going to enter a plea of guilty to one count of assault. This is a third-degree felony. It's punishable by 36 months in prison and a $10,000 fine. It also includes a mandatory period of post-release control of anywhere from 1 to 3 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at that trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the 9-month sentence. Is that what you want to do? Is that a yes? All right, Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about August 20th of 2025, while an inmate at Warren Correctional Institution, Turtle Creek Township, Warren County, Ohio, Jamari Ford struck a CO in the face while serving time at the institution.
Anything on those facts, Mr. Bogan?
Nothing on those facts, Judge.
Mr. Ford, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think you made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Any reason not to go into the matter of the sentence today?
No reason, Judge. It's an agreed sentence.
All right. We have 0 days of jail time credit and no restitution, right?
That's correct, Your Honor.
Mr. Harris, anything from the state?
Your Honor, we just asked the court to adopt the recommendation of the parties of 9 months consecutive to the time he's currently served.
Mr. Bogan?
Yeah, that's all we'll say too. We just ask that you go along with the agreed sentence.
Mr. Ford, anything you want to tell me?
No, sir.
All right. Court is going to sentence you to 9 months in prison. This is going to be consecutive to the time that you're already doing, because the consecutive sentence is necessary to properly punish you. Sentence is not disproportionate to the conduct involved here or the danger posed by you, and your criminal history suggests that a consecutive sentence is necessary to protect the public from future crime. I do find that you are indigent for the purposes of fines and costs, so there will be no financial sanction. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the cost, they will all be provided to you at no charge. This does include the mandatory post-release control of anywhere from 1 to 3 years. Good luck to you, Mr. Ford.
Thank you, Your Honor.
Micaela Magallanes.
All right. Why didn't you show up today in person? I usually require that on small claims.
I
Your
know,
Honor.
my apologies, Your Honor.
This is the case we spoke about this morning where she had a subpoena downtown.
Where are you at?
I'm at the 3rd Judicial Circuit Court.
Why didn't you tell us earlier? That isn't fair to him. He came in here. You could start calling us
Prosecution
tonight.
called me.
What did?
Prosecution called me late afternoon after jury selection yesterday.
Before we go on, I'll remind you, both of you, that you have the right to have the case removed to the General Civil Division. If you want to do that, you can, but if you want to stay here, you can in the Small Claims Division. But if you stay in the Small Claims Division, you're waiving your right to collect in excess of $7,000. You're waiving your right to hire a lawyer, to demand a trial by jury, and to appeal my decision if you don't like it. You understand that, Ms. Magalanis?
Yes, Your Honor.
You understand, Mr. Glista?
Yes, Your Honor.
Do you wish to waive those rights and proceed here or have the case removed? Ms. Magalanis?
I would like to proceed with you, Your Honor McNally.
You waive your rights,
Yes.
sir?
Yes, Your Honor.
You waive your rights? Raise your right hands, both of you. Solemnly swear affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got. Ms. Magalanis? Do you,
Yes.
ma'am? Mr. Glista?
Yes.
Okay. What do we have here? I don't have any escrow agreement. Is there an escrow agreement?
There is. It's title company, Your Honor. Was not my paperwork.
I'm not picking you up now. See, this is why you should have let us know. Look. I hate doing these by Zoom. These small claims. What is this issue? Will you tell me something?
So I bought the house from her. We gave 6 days rent free in the home. In our escrow agreement, we have $1,000 set aside in escrow as a damage deposit. That was to be cleared, and that's it. when we received keys to the house after the 60 days of giving them rent-free, there's a hole in the upstairs back, or upstairs bedroom. The lawn had been.
All right, let me stop you. Do you have pictures?
Yep.
Can I ask you a question?
Yep.
She called late. This was brought to my attention 3 hours ago, roughly. The Civil Department, Civil Clerk came in and talked to me about this. I didn't know what was going on. She's asking for an adjournment, saying there was a conflict. What days do you work?
Monday.
Did you take off today?
Yes, I did.
What time are you gonna be done downtown, ma'am?
I'm still waiting to be set on stand, sir. They are cross-examining the victim right now, and I am to be called.
Do
on
you
the
have a
witness
day
stand.
off when I can do this, when everybody can come in person? I would feel a lot better about it. Do you have a-
Absolutely, Your Honor. I will make that arrangement.
Well, why didn't you? I'm just disappointed you didn't call us. We could have let him know. We didn't have his phone number.
I called, me neither. I didn't have his number either, and I called Miss Wiseman as soon as the prosecution gave me notice.
Let me see what you got. Did you put a hole in his wall?
No, Your Honor, that was actually previously there. We have photos from when that was done, when I first arrived at that property. So that hole was been there
Hang on.
even when they
And
went
you don't
through.
have them with you, right?
What's that?
The photos that show me that hole was in the wall when they agreed to purchase.
Yes, I do. I have photos. Yes, sir, Your Honor. I have those
Yeah.
time stamped on phone,
You have them with you?
on my cellular, yes.
How am I gonna be able to see it from here?
Maybe sent through email.
Jennifer, do you got any suggestions? I hate to have them come back. It's only $1,000.
Your Honor, if she wants to email me the documentation, I can print it.
Email it over to her. Okay?
Yes, absolutely.
Is Brockwood out there yet? With them, Jennifer.
I say, Your Honor, too, there's pictures of when we originally looked at the house and had inspected of the property, what it looked like. After the 60 days, there's pictures when we got keys to the house, of how overdone it was. They have a long there.
So you're saying the holes that you're depicting in these pictures were not here?
Yeah.
Well, what are you showing me the grass for?
So that's when we originally looked at the house. There's the picture of where it's short. That's what the house looked like when we signed on it. And then when we got to keys 60 days later, after we gave them the 60 days rent free, that was what we got the house looked like.
Which one?
All of them. So there's some where it's real nicely cut and green.
Yeah.
When we signed on the house, how the property looked, and that's how we received the property. itself. And then the living or the laundry room downstairs, when we inspected the house, when we did our initial visit to the house, there was no scent, cat urine at all in that back laundry room. We got keys to the house, we had to rip the entire flooring out, the walls out, repaint everything with the Kills paint, deep clean it.
House.
Do you have any questions of him, ma'am?
Yes, actually, Your Honor, I do. I've listened to a little bit of the explanation on the property and how it was well kept. I maintained that property as well as I could in regards with Rockwood Police giving me one notice that my grass was a little over. I did cut it and maintain it for the 2 years, just as so. What they believe to have been weeds, I think it's agreeable to say that what one person agrees to be weeds, one might not. So there are a few shrubs and flowers that were planted around some trees there that they pointed out as weeds. Those were there from the previous owner. They were beautiful flowers that actually grow annually. And there's some that grow pre-annually. Also, before they sent my real estate realtor a receipt for $500 in shrub removal, they were very, how can I say, I was trying to make the matters better, and by offering my father, who is actually a landscaper, to go and remove things for them. But before we could even offer
Let me
that, he
stop
sent
you
a
a second.
receipt
How
of
much did it
500.
cost you to fix that hole?
So it was the entire property, all along the fence line, it's intertwined in the fence, the long weeds.
I know that, but the hole.
The whole, it was $200 for the drywall work, and then they repainted everything, made everything done, so I think it came out to about $500.
Well, where's it at? Give it to
There
me.
should be a receipt in. I think it was one of the bad ones, I had it all paper clipped under receipts. That's no instruction.
And again, Your Honor, I have proof
Wait
that
a
that
minute,
hole was
ma'am.
there when they
Wait,
went for
please
the
wait.
showing.
Please wait.
Yes.
I'm looking at Home Depot receipts here.
It should be one of the first ones in that stack before you get to the pictures and stuff. Oh, yeah, please. Give you something this morning.
Drywall and paint repair, $500. All right, I see. What do you want to say, ma'am?
Just that that hole was there prior to them viewing the home. I've had several people before them that went into the home, obviously potential buyers, and they viewed the home as such, as did they. That hole was there behind that door.
Who's holding the escrow?
I
You got
believe,
the escrow?
It's between.
no, the
both.
title company has the escrow. They will not release it.
So we both have to sign on it to release it, because when we originally.
And he
came-
refused to
Slow
sign on
down,
it.
slow down, slow down.
We originally came to $700 is what we wanted out of the escrow account. She came back with $100, and that's what I said we could look into.
Out of here. Let me ask you a question.
That's right.
He's saying that hole was there.
Yes, sir, Your Honor.
But it was right behind where, so that was used as the bedroom. It was right behind the door where the door.
You have a picture here from before that shows me that it wasn't?
That shows that specific spot. There should be, not in there, but there's pictures of the house online when they did the walkthrough of the pictures.
I mean, do you have a picture in here? No. But you're telling me under oath that was not there.
Yeah.
Why'd you let the property go like that, ma'am?
I was actually under financial stress at that time, even with health being a factor as well. I was unable to maintain that big property on my own. Therefore, I had to sell.
I'm a little confused. You've sued him and neither one. She sued you, but neither one of you hold the $1,000. The title company has the $1,000, right?
Yes.
The title company, Your Honor, told me that I had to take him to small claims court because he refused to sign to release my $1,000 escrow damage that was for damages of the property, not maintenance of the yard.
One of you guys get the title company on the phone or have them zoom in, please. Can you do that for me? Can you do that for me?
Got
I believe it's certified.
Absolutely.
Call the title company and ask them to zoom in. Jennifer, tell her the Zoom number. Thank you. Danny, I'm going on to another case. Danny Eugene Walker, 26B721654.
Mr. Walker.
Lieutenant Detective, your name? You got to unmute.
That's what she said. She said it really doesn't get about game.
It's unmuted. It's still muted. Did you mute them, Jennifer?
I did, Your Honor, when you asked me to.
All right.
I'm
unmute
clicking
them.
it. I'm clicking it to unmute and it's just, it should be popping up on their end.
And I don't know if you can hear me yet.
Yes, your name.
Sorry. Detective Sergeant Morrison, Brownstown Police.
Raise your right hand. You solemnly swear affirming the penalties of perjury. The testimony you'll give in these proceedings will be the whole true self you got.
Yes, Your Honor.
Okay, go ahead.
Your Honor, just one small amendment to the complaint. The location of the address listed on the complaint is 18334 Pine Street, West Pine. It's actually 18335 Pine West.
Maybe they'll change, maybe you guys can change those before you send them over. I'll go ahead and change that on, it's 18335 Pine West, right?
Yep. Yeah, sorry, Your Honor. I guess I've done a couple of those lately. I apologize.
That's all right. Go ahead. You can continue. I'm making those changes.
Okay. Your Honor, this incident occurred on 8/30 of 2026, approximately before 2:25 hours. The complainant is Nicole Walker. The defendant is Danny Eugene Walker, date of birth 3/18/91. Incident to the venue is 18335 Pine West in Brownstown for the point of origin of the domestic. For the flee and elude aspect, that occurred at Telegraph Road and Sibley Road, Brownstown Township, Wayne County, Michigan. So for the relationship, the defendant and the victim, currently married, and reside together at location. For the relationship total is at 3 years and 6 months. Brownstown officers Cormier, Fox, and McLeod were dispatched to 19001 Telegraph Road for a report of a domestic assault that occurred at location earlier. Upon arrival, Officer Cormier spoke with the victim, who reported the assault at the hands of her husband. She reported the following: she was sleeping at home when the defendant arrived home from the bar intoxicated. She stated that he began to pull her off the bed because he was angry about an altercation that occurred at the bar earlier. Defendant pressed his thumb into her mouth and pushed down. The victim went to the bathroom. The defendant began to push her into the bathtub and threatened to slam her head into the tub. Defendant grabbed both of the victim's arms and bent them in opposite directions. She went back to the bedroom and he struck her with the door before punching a hole in the door. Victim attempted to flee the residence and the defendant attempted to push her down the stairs. She fled to 19001 Telegraph Road and called police. There were no injuries reported or observed by police. For the flee and elude aspect, while the victim was reporting this to the police at the gas station, the defendant arrived on a motorcycle and began and pulled up to a gas pump. He made eye contact with police officers and began revving the engine of the motorcycle. Officers began walking towards the defendant, who made eye contact with police and fled northbound Telegraph Road at a high rate of speed, disobeying a solid red northbound Telegraph and Sibley Road traffic signal. Officer Fox and McLeod engaged in pursuit of the defendant. Officers involved were in fully marked Brownstown police Tahoes with graphics, lights, sirens, and were wearing uniforms with insignia and badges. The following events occurred. Officers pursued with lights and sirens. Defendant looked back at pursuing officers more than one time during the pursuit on the motorcycle. Defendant fled northbound Telegraph before turning eastbound Pennsylvania. Defendant fled eastbound Pennsylvania with speeds reaching 100 miles per hour and then turned southbound Rocco. Defendant stopped in front of 17277 Rocco. The pursuit spanned over 2 miles. Officer McLeod was the lead car in the pursuit. When the defendant pulled over, Officer McLeod ordered the defendant to the ground at gunpoint and he refused to comply. Taser warnings were also given, but the defendant did not comply. Officer Fox was second to arrive at the area to stop. During this time, the defendant was agitated and yelling. Officer Fox attempted to de-escalate the situation, began speaking with the defendant, who denied assaulting the victim. Defendant stated the victim pushed him and assaulted him, but declined to elaborate. During this contact with the defendant, he told Officer Fox that he fled the gas station when he saw police because he was afraid he would be arrested. Officer McLeod's report indicates that the contact began with the defendant's refusal to comply, with verbal commands lasted approximately 20 minutes. But eventually, Officer Fox was able to de-escalate the defendant and they began speaking with him to get his statement. The defendant was arrested without further resistance. The vehicle was a 2017 black Harley Davidson, Michigan registration, Zebra George, 705.
Did she sustain any injuries?
No, Your Honor, there were no reported injuries.
All right. Based on your sworn testimony, I find the crimes of domestic violence and flee and elude force were committed. There's probable cause to believe those crimes were committed by the defendant and authorized the issuance of the complaint and warrant. Come on up and state your appearance, if you would, please. Mr. Walker, your name, sir?
My name is Danny Eugene Walker.
All right. Does he stand me away from a reading?
Yes, Your Honor.
You have the right to remain silent here today, Mr. Walker. You have the right to a lawyer, not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You'll be in front of Judge Hessen on September the 15th, 2 weeks from today at 9:15 in the morning. You're also going to have the right to a preliminary exam within 7 days thereafter. That will take place September 22nd at 11:30 in the morning. At that time, the people have to show that the crime was committed of flee and elude forth and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings. If they fail to prove that, the charge would be dismissed. Do you understand that?
Yes, sir.
All right, so probable cause conference will be in front of Judge Hessen September 15 at 9:15. Preliminary exam September 22nd at 11:30. I'll listen to whatever you have to say regarding bond.
You know, my client is personal bond. He's been in custody since Sunday, Your Honor. He's gainfully employed. He works at AGM packing. His income is relied upon. So to continue to function, Your Honor. If he doesn't report, he works today by 6, he reports to the court that he will lose that job. There are no minor children in the common matter. I explained to my client that he had no contact order coming out of this matter at the stage. But he assures me he has a friend making part he will stay with, but he will probably contact with the comment to this resolved. I think the court can call my client attorney and get him snapped off.
You said he was going over 100, right, Sergeant?
Your Honor, yes, that's what the reports indicate, that the speeds reached at least 100 miles per hour on Pennsylvania Road.
15,000, 10%. That shows you're a flight risk. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with Nicole Walker. You cannot write, phone, see, text, email her, or communicate with her in any way. You cannot have anybody else do any of those things for you or on your behalf. You're not to have any contact with prosecution witnesses. You're not to go near 218-335 Pine West in Brownstown Township. No alcohol, no marijuana, no illegal drugs. You're not to possess firearms or dangerous weapons. If you have any, you're to surrender those to the Brownstown Police Department. Do you have any reason to go back to the residence to get personal belongings? If you do, I'm going to give you one visit there.
I have a few reasons. I have my shave kit.
It's fine. I'll allow you one visit accompanied by the police, though. You can only go there with the police. So you post the money and they'll accompany you, but you cannot go back there without them. Do you understand that?
Post what money, sir?
$1,500 you're going to have to post.
I don't have that.
Yeah, they'll let you make as many calls as you need to. Okay. And then
Yes, sir.
once you get out, you can make arrangements and they'll let you go. All right. They'll help you get over there and get all your belongings. Good luck. Thank you.
Thank you, Your Honor.
Thanks, Mr. Crawford. All right. Are we back on?
I didn't call you.
Where's the other file at?
Your Honor, Miss Magnialis sent me a phone number for Grace at the title company, and she is on Zoom now.
Come on up here. This is McCullough Magdalenas versus Robert Glista, 2603398. Ms. Meredith, your name?
Grace Meredith.
Your name? So she has sued him. I'm not ready to make a ruling. You guys hold $1,000 in escrow, right?
Correct.
All right. So I'm going to simply indicate on the small claims judgment how much is to be tendered to Miss, even though she sued him, he doesn't hold the money. I'm going to simply indicate on the small claims judgment how much is to be returned to Ms. Magdalenas and how much is going to be forwarded to Mr. Glista. You understand that?
Yes.
Now, just give me 1 second. What is the name of the title company, ma'am?
Title Solutions Agency, LLC.
And you acknowledge you work for them and you're holding the Title Solutions Agency LLC is holding $1,000 in escrow between, and this is for the transaction involving the parties, correct?
Correct. We're holding $1,000 from the seller.
Right. Right. Okay. What else would you like to say to me, Ms. Magdalenas?
I'd like to thank you, Your Honor, for allowing me to show up on Zoom first. I mean, that's
That's fine.
Thank you very much.
That's fine. Don't worry about it.
Other than that, and I would like to rebuttal on that hole in the wall, because honestly, that was done by my son during our time of stay of the 2 years there. So that hole was there during their viewing of the home. Whether or not they pulled the door away to see it, that's again not on my end. I wasn't there for them viewing. And I just really wish this just didn't have to be here today. I just really wish it didn't go this far.
Anything else? Anything else?
Well, other than that, the laundry, lawn care, home set. I did have to take off work today, okay, so I was putting in loss of wages today as well.
I can't give you that. So without the lost wages, how much do you think you're entitled to?
It came out to like 1,600 total, so we only had 1,000 escrow. I gave her the option originally to pay 700. She still
I don't want to know about your settlement offers. I'm just here to address what's to happen with the $1,000 though. I want you to understand that.
Yep.
She sued you. You didn't counterclaim against her.
Yep.
Here's my order. I think you did put the hole in the wall, unfortunately. And I think that the grass is a disgrace. I'm ordering that the $1,000 held in escrow by Title Solutions Agency LLC to be released as follows: $250 to be released to the plaintiff and the balance to defendant. That's $750. And there are no costs. I'm not going to assess filing or charge anybody for filing fees. You ate that up wrong. Okay, that's what I'm doing. I'm going to ask you to release that. If you chat with the Jen W here, you tell her where to release the order to, and we'll send it along. Thank you very much.
Thank you, Your Honor.
Is Sean Reed out there?
I think they're coming.
Sean Reed versus David Stark, 2603066. Did you guys resolve this?
Yes, sir.
Yes.
Come on up here. Your name? Sir, your name?
David Stark.
What is the resolution?
We decided that we're gonna, the survey is a couple feet off, well, my surveyor said that, so I'm gonna get a letter. There's a little bit of discrepancy, so they're gonna talk and then finalize that, so I can walk on the side of my house.
You sued him for $100. What am I doing with this?
Well, I was thinking about, cause I wanted to get the poles taken out, because I was thinking my survey would override that survey.
We already heard this case, didn't I?
Yes,
Well, why are you back here? I don't understand why you're back here.
you told me to talk to my lawyer and make sure that I can follow through with this, because I have another suit. at
Slow
First
down.
Circuit.
Yeah. What are you doing back here?
You told me to come back and we finish it, you left it open.
No, I didn't.
I swear, I would never come back if you didn't tell me that.
Jennifer, do you know anything about this? I could remember them being in here and talking about a survey.
Yes, Your Honor. Let me pull the last
Could
case
you
up.
look at 2601964?
They were here on June 29th. Let me pull the actual packet from that day. Give me one moment.
I thought you guys just agreed to go over to the circuit court because you had a case pending.
No, not in. That's something she's got.
I don't even know what you're suing him for, to remove iron rods on property not placed in correct spot and not performed by licensed surveyor or under supervision of one. What's the $100 for?
He said he was gonna help me take them out, so I was gonna have somebody else take them out for me.
Your Honor,
So,
If you agree with it.
wait, what? Yeah, Jennifer.
you dismissed it without prejudice, and your other notes on the dismissal indicate case pending in Wayne Circuit Court, which addresses property line dispute.
What am I doing? I don't understand what you're doing, Miss Reed.
I can get the transcript, I'm not gonna argue with you, but you did say that we'll finish it after
didn't say-
my
I said-
my lawyer probably go through with it.
You got a case pending in circuit court that addresses these issues and the boundary line dispute, right?
Yes, when I can't walk on the side of my house.
Slow down
I'm
a
being
second.
arrested.
Ma'am. How am I gonna intervene? How am I gonna intervene in that suit now? You have to go in circuit court. They're the appropriate authority to deal with that. I just don't even understand what you're saying.
I'm doing a quiet title.
I know you are. I get it. I remember this.
And now the survey is incorrect. My surveyor said so, so I'm gonna get a letter from him or him come back out.
I'm dismissing this without prejudice again. I'll do that for you. I don't know what you want out of me. You're gonna have to finish your suit in circuit court.
But I want to use my survey. When we pay $5,500 for it, can I use my survey?
Do you have a lawyer in circuit court?
Yes.
Ask him or her those
She
questions.
said that I can, but the city doesn't seem to think that my survey is good enough.
I'm not, hang on. And you're suing him. I'm not getting involved in the suit that's going on in the circuit court. I think I told you that before. It's not my province. You got a quiet title action. The judge there is going to make his or her decision.
Mhm.
I'm not overriding it. And now you got $100 amount of money claim to remove iron rods from property that's probably the basis for the Wayne County Circuit Court action, right?
The survey, I think, is incorrect and is landlocking me in.
It might be, but it's going in front of circuit court.
For 4 years, we've been going through this.
Ma'am,
So,
if it was mine to decide, I would do it for you. It's not mine to decide.
okay, well, I'm gonna use my survey then because my lawyer's.
Ma'am?
So,
I'm dismissing your case without prejudice.
okay, thank you.
You need to talk to your lawyer about what's going on in the circuit court case.
We have. It's going to trial.
Then
And he
let
said
it,
that I could, if the survey.
he didn't tell you to come in and sue Mr. Stark for $100 over these iron rods that you want moved.
Well,
I can promise you that. He didn't tell you that.
well, there's no meets or bounds or a map to the survey that he has.
Ma'am, it's not my province to deal with that. I'm sorry.
And I have a
Ma'am,
survey.
talk to the Wayne County Circuit Court lawyer.
Okay, I'll go ahead and talk to my survey.
And can I say one?
No, I'm done with this. This shouldn't even be here. The case is dismissed without prejudice.
Okay.
You gotta see what happens in the circuit court. Jennifer, prepare an order for me to dismiss without prejudice, will you please?
But just to be correct, my survey is
Ma'am?
good.
Ma'am,
Just one-
ma'am, do not put words in my mouth,
Oh, I'm just wondering, so I don't do anything wrong.
ma'am. You've got a case pending in the Wayne County Circuit Court.
Yes, sir.
It's a bill to quiet type, right?
Yes, sir.
That judge is gonna rule. I'm not ruling anything today. I'm telling you the same thing I told you a few months ago. See what the circuit judge does. I'm not ordering this man to pay $100 over some rods that may or may not be part of that suit, and it looks like it is. I'm dismissing without prejudice.
Okay.
Do not leave here thinking that I'm saying anything other than I'm dismissing. Well, but you gotta put words in my mouth before. I did not say come back here. I said, wait for.
You said, well, finish it. Ask my lawyer if he thinks it's a good idea that you stop me. You're looking out for my best interest. And you said, ask your lawyer. You had me call the lawyer when I'm
Ma'am,
sitting here.
I remember.
Put him on
Ma'am,
speaker.
ma'am,
Okay.
go finish your action in circuit court. Okay?
Okay.
Don't come back here until that's over.
Okay, I won't.
Okay?
But I am using my survey though. So my lawyer said I could, so.
Ma'am, I'm not saying you can. I'm
Okay.
not saying you can't. I don't know one thing about what's going on in circuit court.
Okay.
I'm not presiding over that case. I got enough of my own problems
I
here.
hear you. My mind's on it.
Good luck. Thank you. Thank you both. Have a good
Thank
day.
you.
Like that, they're in Michigan court rules, or the case is decided thereunder. To the extent a conflict does exist, given waivers, the court will consent to hear the matters. Are we ready on anybody? Williams?
The first one's in.
Oh, it was in Zoom. Okay. Court does call the case of the People versus Antonio Williams.
Hey, listen, now we have people, Your Honor. I believe this is Mr. Gary.
Oh, I'm sorry. Mike Gaddy, Assistant Public Defender on behalf of Mr. Antonio Williams, Judge.
All right. Mr. Williams, can you state your name, please?
Antonio Jose Williams.
Okay. The last report I have that was received August 12th, dated July 30th, indicates that the defendant remains incompetent to stand trial.
Yes, Your Honor, I don't object to that. I don't object to that report. I did have a chance to talk with Mr. Williams yesterday and explain to him where we are in the process.
We'll stipulate to that report.
Yes.
All right. Based upon that report, the defendant at this time remains incompetent to stand trial. We'll set a competency review for December 3rd, 2026, 9 a.m.
Thank you, sir.
Thank you. Bond will continue. Thank you, Mr. Williams.
All right, thank you.
Court does call the case People versus Stephen Javon.
Good morning, Your Honor. Ashley Feltus for the people.
There's nobody there. All right, I'll pass that.
I'm sorry,
Oh.
Judge, he's is on his way down. He just had not came yet, but he's on his way down.
Okay, we'll call the case once we see him on camera.
All right, thank you, Justice.
Who do you have coming out? Daly. Court does call the case People versus Gary Lee Daly.
Ashley Feltus for the people.
Excuse me, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Daly. Your Honor, I believe we're seeking an adjournment in these matters.
I've got 3 tickets
Yes.
and all of them.
Yes, Your Honor.
Uh,
I will do a green sheet immediately.
is this the only thing holding, Mr. Daly?
Give it to us. He has a parole hold, Judge.
Does. Okay. 17th or 24th.
17th, Judge.
Probable cause conference will be adjourned September 7th, 2026. AM bond continued.
Thank you.
Thank you, Judge.
Somebody did your job.
Go ahead.
Court recalls the case of the people versus Stephen Javon.
Ashley Feltus for the people.
This is Mr. LeBeau's case, but I think you can handle this, Mr. Gaddy. I have a competency report dated August 3rd, received August 24th, that indicates the defendant is not competent at this time to stand trial.
We haven't had a chance to, I haven't had a chance to go over that with him. May I approach briefly to look at the report?
May.
You could state your name.
What are we doing?
Your Honor, we're asking for an adjournment of this matter. We are trying to get an independent evaluation for him that has commenced. I just don't think we have the report yet.
So, an independent forensic.
Yes, Judge.
And we just don't have the report at this time. Is that what we're?
That's correct, Judge. That's what I am informed by.
All right. I'll then adjourn this to September 24th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. So, court does call the cases of the people versus Matthew Gibbons.
Ashley Feltus for the people on all 6 matters, 8 matters. Assistant Public Defender. Carry on. On behalf of Mr. Gibbons on all 8 matters.
Yes, he's on Zoom.
Your Honor, I have not had an opportunity to make contact with Mr. Gibbons. In the past, my colleague, Hannah Apple tried to, she waited for about 45 minutes. The facility did not bring him up. When I went in to secure my ability to meet with him, it just said that there are no open availabilities to meet. I have a copy of what.
What does that mean?
It just specifically, Your Honor, there are no visitation appointment times available. This may result when the inmate already has visitation scheduled. I mean, it was just completely grayed out for months. So I don't.
For how long?
Your Honor, this isn't true. This isn't true. They brought me up to see them, and there was nobody there. This case is affecting my parole being held up here. On the 22nd of October, a 6-month waiver was sent out to the Washtenaw County prosecutor, something Elliott, and they never responded. So this whole thing is just holding me up. How long do I have to sit in purgatory waiting to be tried for a prelim on charges that should be dismissed as soon as the motion goes through anyways?
So,
Mr. Gibbons, first of all, I appreciate the information. I have 8 cases here and I don't know if what you're indicating is applicable to all 8 cases. We have had not just your case, but numerous cases where attorneys have gone to visit and they can't get in to see the inmate. I don't know what's explained on your end or what's happening, but they're showing me emails and other things indicating that the communication to the public defender's office was that you were not available. So we got to try to figure that out.
I know 2 weeks ago, they brought me up here and I sat here for an hour waiting to see somebody and nobody ever showed up.
Right.
I know that for a fact. I know that people sit on these video visits all day with their family. I know that with
Mr. Gibbons.
They've had a month.
Mr. Gibbons. We can sit here and argue about it. I've seen the email. I don't know what it is. I'm not in charge of that. Okay? They were there. I don't know what the disconnect is.
So, Your Honor, we can go ahead and set these matters for preliminary examination and have him read it out in person. That will give us an opportunity to absolutely meet with him. My understanding is discovery is complete. Obviously, we have not had an opportunity to review it with him. But Mr. Gibbons, if you're prepared, we can go ahead and set it for exam. Your Honor, I have that he's got an earliest release date of January 4th of 2027. That's all the information I have right now for what is currently holding him.
All right. Which facility? An IBC.
IBC.
So we're going to need at least 3. So them to bring him on the 8th. Well, we're on, so 22nd. So discovery being complete. Would the people have their witnesses available the 22nd?
We'll try, Your Honor. Thank you.
All right. Preliminary examination in these matters will be set for September 22nd, 2026, 9 a.m. before Judge Barr, all 8 cases.
Thank you so much, Your Honor.
Continue. Thank you.
Did you get all that, Mr. Gibbons?
Yes, thank you.
Or calls case, People versus Durrell Frederick.
Ashley Feltus for the people. Assistant Public Defender, really, Your Honor, standing in for First Assistant Public Defender, Torchio Feaster. Judge, he indicated that he's at the door with an exam.
Who?
Feaster, Judge.
No, he's not. I don't know why he's not here.
What'd you say?
I don't know why he's not here. Why?
Somebody tapped me on my shoulder.
He's not next door. He's next door. He's not in an exam.
I've had eyes on him.
I don't know what. No, I'm telling you right now. Can we be? All right. That's what you want. That's the story you're going with?
Judge.
I'll let you make something up in a moment. Name? Frederick. Thank you, sir.
Judge, we are asking for an
Go and check if he's not even. He was here and then he left.
Oh,
really?
Out of this courtroom.
And you just get up for him.
He skipped up, right? So
he skipped.
All right. You're requesting an adjournment then?
Yes, Your Honor.
Investigation. Yeah, grant that adjournment. How much more time did you need?
Because I think 2 weeks since he's in custody is fine.
All right. I can, because we're on a Tuesday, I can do this. Is this the only thing holding him or do you have other stuff holding him?
He's got other matters.
Other stuff. Okay. Then I'll adjourn it out to September 17th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you. Thank you, sir. Court calls case, People versus Lewis Chandler.
And then on behalf of people, Your Honor.
Good morning, Your Honor. Sam Bernstein with on behalf of Chandler.
I
should say no.
Oh, Lewis Chandler. All right. This is your motion?
Yes, Your Honor.
Okay.
You were retained on this case?
I was helping him with the arraignment process, Your Honor. We got him turned in and went before the magistrate and spoke with the detective so that he wouldn't be arrested on the street. But like long-term big picture, I don't think I'm going to be retained for the entire case. And I just want to make sure he has counsel working immediately.
Was permitted to withdraw. Grant the motion. This is a public defender case.
Assistant Public Defender, Shanazi Carey, I can rule, Your Honor. What's your name, sir? On behalf of Mr. Chamber, nice to meet you as well. Your Honor, we'd be asking for an adjournment in this matter, at least to familiarize ourselves with the case, Judge.
Public conference, September 24th, 2026, 9 a.m. Bond continued.
That's the 24th, right? I was trying to write.
No, I'm not talking to you. I'll talk, Mrs. Enda. I'm not talking to you. Yes, Mrs. Enda. It's a Senate.
Sunday, next release. It is on next.
It is on. You guys be ready by next week? I mean, I'll set it for next week.
We'll do our best, Judge.
Just don't want him coming down, and we might have to adjourn it anyway, but if it's already set, we'll just continue it to the.
Okay.
All right.
That's 9:10.
Yep, 9:10.
And Judge, my client wants to let the court know that he went out and bought a brand new pair of pants just for this hearing.
I didn't notice. Yeah, I didn't say he had to get something new. I just the whole band. All right.
All right, thank you.
Take care, sir. Those are nice. Court calls the case, People versus Jacob Antonou.
National. National is for the people.
Yes, Ashton. I'm sorry.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Ashton.
Your name, sir?
Jacob Ashton.
All right, what are we doing?
So, Your Honor, ultimately, we're hoping to waive the preliminary exam and get this moving to circuit court. There is the bond violation too, if the court recalls from last week. We're prepared to admit to that violation, Your Honor.
Okay.
Yeah, this morning.
All right, I'll indicate defendant's admitting to the violation. He's waiving up on all of this.
You think this is best?
Do the people have a position? How long has he been in on the panel?
Been in jail, Your Honor, since last Thursday.
Got it. All right. He admits to the violation. I'll sentence him to 6 days. Washington County Jail, credit 6 days served. Then previous bond will be reinstated. All right, so you're waiving preliminary examination on both of these matters?
Correct, Your Honor.
To understand that that's where the people have to show by probable cause that the offenses alleged were committed and that you committed them.
Correct.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
Will also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the single count in each case.
Thank you, Your Honor. Take care.
No, we're not done.
Oh, sorry. Judge, we acknowledge receipt of the information. Ask the court to please waive reading, and Mr. Ashton stands mute, and we ask for a circuit court pretrial date.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for October 26, 2026, 1:30, Judge Oda. All right. Bond will continue as it's previously reinstated. Thank you.
Thank you, Your Honor. Thanks for going. That was bye. Appreciate it.
Judge, may I have the information?
Yeah, it momentarily.
Yes, Your Honor.
Court does call the case, People versus Warren Abbott.
National Felons for the People.
And good morning, Your Honor. Assistant Public Defender, Shanazi Carey, on behalf of Warren Abbott, I believe he's on Zoom, Judge.
Good. Okay, Mr. Abbott, can you state your name, please?
Warren Abbott.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment in this matter. Mr. Abbott has another matter that's currently at the district court. So this isn't the only thing holding him. We're in negotiations with the people.
The other matters at circuit?
It's at district court. It was here, and then I think that he had an exam and the
Down.
felony, yes, was dismissed. And
When is that set for?
Mr. Abbott, what's your next court date on at 15th District? Do you know it?
Yes, ma'am. It's October 14th, 2026.
Whoa.
I think he also has a pending case in circuit court, Your Honor, so there's quite a few.
Sure. Thank you.
Then why don't I do this the 17th? That's 17th or 24th. What's gonna work for you guys?
This 24th, Judge.
24th.
Please.
Probable cause conference in both September 24th, 2026, 9 a.m. Bond on these matters will. Okay. All right. Thank you, Mr. Abbott.
I'm sorry, I didn't catch that last part.
Which last part? I've adjourned these, got us, from what I hear, you got circuit court matters and you think district court matters. So they're trying to do something, a global type of resolution. So I've given them to the 24th to try to see where we can get on that.
Yes, sir.
All right. So thank you.
Thank you. First,
Court calls the case, People versus Tepe Meredith.
That's the office for the people.
Good morning, Your Honor. Sam Bernstein here on behalf of Miss Meredith.
She's not here, I take it.
I don't really have anything for the court. I just learned of Miss Meredith yesterday. My letter didn't make it to her yet.
Meredith, not here. Bench warrant will issue for defendant's failure to appear. Bond set in the amount of $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls case, People versus Phoenix Born.
That's the office for the people.
Good morning, Your Honor. Christina Saxon, Phoenix Born.
Your name?
Yes.
Okay. What are we doing?
Your Honor, may we approach for a moment?
You may.
Thanks.
What? Thank you. Court calls the case, People versus Teresa Heichel.
It's for the people.
Oh,
Miss Frazier, who's sent and don't get her.
who's on this?
Miss Frazier.
Just thought we couldn't see her. Check behind the podium. Yeah, like, what? Alan, why you do me that way? Oh, Lebo is here. How are you, sir? Morning. We were looking for you. I stuck up and defended you.
And that is greatly appreciated.
It is. You should have heard the things that can really was saying. It was horrible. It was getting bad there for a while.
Realize a whole every single step on kilter
Michael? Good morning, Your Honor. How are you doing this fine day?
Just wonderful. Thanks for strolling in.
I'm sorry, I didn't stroll faster.
No, you're not. You have a client? That'd be negatory ghostwriter. No, why can't they come out of your mouth?
No.
Hi, Joe. Not here. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of, $10,000 cash surety. That warrant will issue immediately. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Tommy Butler.
People?
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Butler.
Tommy Butler. Got it. All right.
So this is a remand from circuit court, so discovery has already been completed, Your Honor. We're hoping to get fastest.
Well, and I just want to make sure that we just received the order, but I don't. Is it being brought back to have a prelim?
Yes.
And is it just on the best we were able to determine, there were initial counts. I don't know what happened with those. And then there are additional counts.
Yes, sir.
Is the prelim on everything, or is the prelim on just the additional counts?
I would say just the additional counts. I don't think we're relitigating what's already been found over.
That's correct, Your Honor, but the original, the AWIM and all of the counts that were initially dismissed have been refiled, is my understanding from my conversation with ABA Overwater. So it would be an exam on everything except for the firearm possessed by a prohibited person and the ammunition possessed by a prohibited person. Those have already been litigated in front of Judge Perry.
So can somebody explain to me what happened?
Yes.
This is unusual.
At the time of the initial examination, people were unable to proceed as to count one, self-defense murder. We did not proceed on count two, felony firearm, third or subsequent offense. Count 6, I believe, carrying concealed weapon, 5 carrying concealed weapons, and carrying with unlawful intent. Since the time of the initial exam, during the exam was completed, the defendant was found over on the counts of felon possession of ammunition, possession by a prohibited person, possession of prohibited person, both firearm and ammunition. At the time of the examination, the defendant was granted a PR bond by Judge Gallo. And then between the time of that and getting up to circuit court in front of Judge Conlon, there was a bond violation, which resulted in a remand by Judge Conlon and resulted in additional charges of witness bribery, intimidation. So now we have been able to secure additional witnesses, and we do believe we'll be able to proceed on the counts that we initially dismissed because we were not able to proceed at that time.
Okay, so I have, number wise, I'm up to count 13.
That makes sense, Your Honor, because I think that we added those back in as added counts rather than reviving counts 1 and 2 and all of that. So we now have count 3, possession by a prohibited person, count 4, possession by a prohibited person, firearm and ammunition respectively. So I do think that we're going to be having an exam on counts 8, 9, 10, 11, 12, and 13.
Okay, all of that's fine. But trying to figure out. It didn't come back then on counts 1 and 2.
No, my mistake here. It's the same charge, but different numbers.
Whoa. That's what's gonna be a mess.
It's been a ride.
What?
Been a ride to get here.
Well, I'm just trying to figure out, has he already had an exam?
Yes, there was once an exam.
And was there testimony? 'Cause
Yes.
it wasn't before me.
Yes, there was testimony.
There was testimony as to which counts. I mean, I'm trying to figure out what is he already bound over on? Because this is gonna go back before Judge Perry, but I've got to kind of,
It was a visiting judge that day, so it wasn't actually Judge Perry.
Counts 3 and 4, Your Honor.
was it Judge Valvo?
Yes, Your Honor.
Yes.
Okay, so Judge Valvo heard a preliminary examination. He was bound over on counts 3 and 4. You couldn't proceed on 1 and 2.
We dismissed those before the exam started. Yes.
Okay.
And also, 5 or 6 and 7.
So 1, 2, 5, 6, 7 were dismissed.
Magnolia, yes, Your Honor.
Okay. And so what I have now is, just had it in front of me. I have account 3 and 4. Eight, 9, 8 through basically 13. So is he set currently for pretrial before Judge Conlon at some point? Or
September 30th, Your Honor.
when?
September 30th.
Your Honor, I will apologize. The court only got the order. I just hadn't seen anything happen with the remand order for 2 weeks, so I went ahead and just emailed it to court staff to make sure that we weren't just going to be stuck in limbo. So if there's any additional documentation this court would like from circuit court, I'm happy to send that along. I just sent along that initial order to make sure we got this going.
Right, but if he's set for the 30th already, rather than have it pushed out, I want an exam as soon as possible so that then he can get if he's bound over on it, everything continues to that date. That's what I'm looking to do. So we're gonna because you got a problem with my numbers. No, go ahead.
According to the clerks, there was never account 7 any.
There was never account 7.
So they have to be amended as 7 through 12.
I heard that, Your Honor. I'll take care of it.
But was there account 7?
No, Your Honor, what it appears happened is that there was initially a charge requested that we denied, that our system numbered as count 7. I apologize for the numbering error. I will have an amendment.
Okay, got numbered in your system as 7, but we never had it.
So I can fix it and get it in.
Okay, so it's really 7 through 12. And so we're gonna have there's gonna be an exam on 7 through 12.
Sounds good, Your Honor.
Okay.
Okay. Are you going to get to me an amended information that corrects these numbers?
Yes.
Because, okay, that's where.
I'll have Mr. Omar work on that while we're here.
Good enough. So I'll set a preliminary examination in this matter. Well, It was Judge Perry's case initially, but there was a visiting judge. But I think the best thing is to send it when I don't want judge. I don't think it matters because these are all new. It's not like it's coming back. And we're going to have somebody here. Somebody's going to hear the information.
Do you have some out-of-state witnesses from home? I spoke with Mr. Overwater about his availability. There's an obligation the morning of the 8th, but will be available the afternoon of the 8th.
Will the witnesses be able to be here?
I don't know, Your Honor. They reside in Illinois.
Because I was looking at the 15th.
I think that would make more sense.
I was looking at trying to do the 15th. That way, whatever he's bound over on, we can try to get set for the 30th.
Yes, Your Honor.
Along with his other matters.
My request would be the 8th, Your Honor, that this has been the dynamic that's another exam would happen has been known for like a month now. And so the gathering of witnesses to get to an exam, it's not just like new from this point. They've known about this since this became an issue.
Yeah, I mean,
weeks ago.
The problem for me is I got the order and I wasn't sure what was being remanded. And then I get an amended complaint and I'm not sure what that is. I'm also unclear from the order from Circuit Court whether or not this gentleman was going to have an exam as to everything or just part of it. And that's just clarified before me today. And so I'm just trying to do something where both sides, and I don't know what you guys knew because, nobody was communicating with us except the order. And like I said, this is very unusual as to how this is happening. And more importantly, what I don't want is a circumstance. If I set it for the 8th, they're not ready to go. Okay, that's fine. Maybe they have some of the witnesses. You go up and then we get this, just call it crazy procedure where all of a sudden he's back having to have the exam on those cases that they had to dismiss because they didn't have the witnesses. So what I'm going to do is I'm going to set preliminary examination in this matter for September 15th, 2026 at 9, and that's going to be before Judge
Freshour.
Okay. All right. Before Judge Freshour. I don't know if whatever's bound over. Counsel, you're going to have to make sure because I'm not sure what dates we're going to get. But if whatever he's bound over on, you're going to have to let Judge Freshour know to try to set it for the 30th so he doesn't have 2 dates.
Yes, Your Honor.
Okay. All right. Bond will continue.
Thank you.
Court does call the case People versus Brian Laster.
Ashley Phelps for the people.
Yep, Assistant Public Defender Chinazi Carey, I can rule Your Honor on behalf of Mr. Brian Laster. Is he on?
Mr. Laster? Got to get unmuted. While he's doing that. Yeah, you're unmuted. Mr. Laster, state your name.
Brian Laster.
All right. And do me a favor this time around, keep your hands where I can see them. All right. What are we doing?
Your Honor, this is a time and date set for a competency.
Yes. And I have an August 17th report.
Your Honor, I believe we do have that same report. This was Mr. Gaddy's case. He reported to me that he's had an opportunity to review the report, and our office has no objection to the findings in the report.
That he's incompetent, but likely horrible.
That's correct, Your Honor.
All right. Then I'll set on all 3 matters, I'll set a competency review. For December 3rd, 2026. 9 a.m. All right, his bond will continue. Thank you, Mr. Lester.
Thank you, Judge.
Counts on that last matter approach.
We've lost Judge.
Court calls the case people versus Shakia Stewart.
Thank you, Roger. And good morning, Your Honor. Assistant Public Defender Alexis Sir, on behalf of Ms. Stewart, on case ending in 5190.
Good morning, Your Honor. Christina Saxon for Ms. Stewart on case ending in 4217.
Your name, ma'am?
Shakita Stewart.
Thank you. What are we doing? Adjourning?
Your Honor, that was the plan on my case. Needed to work on plea negotiations.
And on my case, because I was just appointed yesterday, I need time to get this.
All right.
But I also need to make a bond modification.
Pardon?
I would like to make a bond modification.
All right.
Motion.
I'll adjourn these out to September 17th. Well, no, I'm sorry. I'm going to go September 24th on these. And bond modification, go ahead.
Your Honor, Ms. Stewart is on a GPS tether. It's my understanding that the alleged victim in this case was not a resident of her apartment. He was just there for a weekend. His actual residence, which he provided to the police, was in Garden City. And with that, they should not have any interaction given the distance. And also she's the mother.
So she's been precluded from the residence. It's her residence?
It's her residence and she is back in her residence. He does not live there. He never lived there. He was just there for a weekend visiting. He got his belongings and has not been back since, to my understanding. And his residence is Garden City. So I don't see any interaction happening unless he comes to Ann Arbor or Ypsilanti. Or Ann Arbor, I'm sorry.
So what, you're asking me to remove the tether?
The tether.
I'm not going to do that. I'm going to leave the tether in place because I don't know. While he may reside there, I don't know if he's going to come back. I understand the representations, but at this point, I'm not going to.
Then lastly, I would ask for just a 24-hour motion or permission to travel. She has 6 children that she has to deliver to their father in Youngstown, Ohio. And they start school tomorrow and they reside there. So she needs to deliver them there. I have his name, address.
So there are 6 kids that need to go to school. They go to school in Youngstown, Ohio.
Correct.
All right. Sorry, but Michigan's got good schools anyway. And you need to take them there. Is that right? Yeah.
Correct.
Oh.
So it's just be a 24-hour.
Well, is that going to be enough time for you? I mean, if you got to deliver 6 kids, it's not anything. I don't know what's going to happen. I will do this. You can, I don't know that I need to place a time limit on it unless somebody else sees a reason why I need to. I think she can go down there and make sure her kids get in school and then come back. So she can travel, prepare an order, just indicating that she can travel to Ohio for purposes of delivering her kids so that they can attend school.
Okay.
I mean, I'm not gonna, when were you going?
Today.
Today? So it's a good thing I'm saying yes. Huh? When do they start?
Tomorrow.
Okay, all right. Then she can go and do that.
Okay.
She's gonna stay down there for a day or so. I'm not gonna have a big issue. So. Okay.
Okay.
All right.
Your Honor, I'd mirror that request then on my case too, because
Pardon?
I'd mirror that request on my case then too, give
If somebody would,
similar bond conditions.
yeah, if they would just prepare an order for me, I'll sign off on that. Not a problem.
Okay.
All right.
Thank you.
Thank you.
Court does call the cases of the people versus Curtis Jones.
And then now we have to go on to cases.
Good morning, Your Honor. William Amadeo, P7619, for behalf of Mr. Jones. Plead to my right.
And good morning, Your Honor. Assistant Public Defender Alexis Dirks on behalf of Mr. Jones on case 1435 and 0983.
Okay. You have two cases?
I do, Judge.
Okay, so 2 and 2. Got it.
Right. So, Judge, a couple things. One, I'm sorry.
Curtis Jones. Thank you. All right.
So, Judge, we're going to plead guilty on the bond violation, first of all. I was going to have him waive up on the 2 felonies. I was told by APA's end that there is a new felony.
That's correct. There's felonious assault up for a rate today. I believe on the ring was Mr. Jones. The
New FA.
And that's right. I believe before Mr. Jones failed to appear earlier, I just had Mr. Oda had spoken about. So this is something that came up recently. It was something that was charged a little bit ago, and I think it's just catching up with this stuff. So it was during.
And is that's not the bond violation?
No, his bond violation, Judge, is he didn't appear for court.
Well, that he didn't appear for court.
Right. And I'm told, Your Honor, that.
Which court? This one?
Our court, yes, sir. And I'm told.
That normally, in and of itself, wouldn't be a bond violation. That would just be a warrant.
Well, it was a bench warrant, I should say.
Okay.
And he was picked up on August 17th.
Hold on a second, though.
Yep.
Because I have, and this may be what Ms. Sende was talking about. I have a bond violation in these cases, but it sounds to me, which is why the admission to the bond violation, I don't think he wanted to do.
No.
Violation was the felony, which I think is being arraigned today.
Correct. So.
Okay.
So I guess the cleanest way, Judge, he'll accept.
No clean.
I know, I get it. But he'll accept responsibility for missing court. He's been sitting for 15 days. I'm not going to have him plead guilty.
Yeah, but that's not why. Is that why he's in?
He's in for the bench warrant. That's correct. That is why he's in, sir.
On the 25th, I left the bench warrants out. He didn't appear June 25th.
June 25th, correct. And he was picked up on August 17th, I'm told.
Well, I'm an.
Yeah, he has a bond denied on for that benchmark on his 2 cases that he had prior, and then while he was in the failure to appear status, a new CCW case was charged and his bond in that one like $100 due to his bond being denied, and then he also has the other new case that he picked up. He has a CCW that he picked up, and then the FA case.
Well, I've got 2 CCs.
Correct. One of those I think is older. One is newer from August, and then today he has the felonious assault that he picked up that I charged that's on bond for the CCW control substance possession FAB case. He was on bond for those. We picked up this new FA case. He's up for arraignment today. for longer, not gonna say yet. And then at the time you feel to appear on the other cases, I believe I let the court know about the other FAs where he's on video with the gun coming out of his waistband, wrapping it. And he did not appear before that day.
And Judge, I can't speak intelligently on the FA because that's not my case, at least not yet. But I do know he didn't appear in June. He was picked up in August. I want to waive up to get everything globalized in circuit court. I was going to ask for his bond to be raised.
Not gonna, that's what I'm getting at. I figured what you're trying to do, but he's got something in circuit court. But and that's fine if you want to waive up. The problem is there are still 3 cases that will be here. It's my issue. But I mean, not necessarily my issue, but if you're trying to get everything together.
I mean, logically, it makes sense for everything to go downtown. But with that being said, I'm kind of in a holding pattern until he gets arraigned on the new file.
Are you? So I'm going to ask you a question. I know you're not going to know the answer to, but I'm going to ask it anyway. Do you know if there's going to be a conflict on his new case?
Your Honor, it's hard to say. Not seen the complaint yet, unfortunately.
Here's the best thing to do. I'm going to pass this, have him taken back. I'm going to get the other file. I'll just do arraignment. He's here. It's likely it's going to go to the PD, but at least then you guys can figure that all out and then figure out what we.
And Your Honor, just for the record, in one of my matters, it was just recently arraigned on August 27th. So we just got discovery this morning. So we were going to be asking for an adjournment.
In any event.
Yes.
Okay.
Not had a chance to go over the police report with Mr. Jones.
So, Mr. Amadeo, if you don't have, is this the only thing you have today?
Yeah, and I do have to get the line away for the murder.
I know. So what I'm going to do is I'm going to pass it. I'm not going to do the waiver today. Adjourn these out to the 17th because I don't think he's going to be going anywhere. I'll adjourn it out until September 17th, but let's get his arraignment in here so that then everything's together. You understand that, young man? What I'm trying to do?
It's for your benefit to put everything together. Judge is trying to get you arraigned today.
17th.
Yeah, but right now he's not going to let you out with a new case. And I don't want to speak for Judge, but we're all trying to work in your best interest to get you waived up and have everything joined together. And Judge, could the public defender's office do the arraignment? Could I be excused to go to Lanaway?
Yeah, that's why I said that's why I was giving you the date.
Right.
So that then we'll bring him back out. I'll arraign him on that one. We'll set it for the 17th.
Okay.
That way.
Thank you, Judge.
All right. Thank you. Look, the team.
You still waiting?
Now, on second thought, I think what I'm going to do on that is, I'm not going to do the arraignment. Can we just let Paul know when they do the arraignment to put it for the 17th? Okay. That'd be an easier way. Yes, sure. Thank you, sir. Court calls the case People versus Male Ominsky.
Repeating, Your Honor, Assistant Public Defender should not be carried out rule, Your Honor. On behalf of Ms. Molly Ominsky, Judge, is she in? No?
She is.
I didn't even blush.
Yeah, you did.
Your Honor, I'm going to be asking for an adjournment in this matter. When I went to meet with Ms. Olinsky,
Ominsky. Sure. Okay, what are we doing?
Mr. Bartolacci is currently hospitalized. I'd be requesting an adjournment in order to make contact with him.
Local here, is that the deal, or?
I believe he's at the VA.
Got it. Okay. Probable cause conference will then be adjourned to September 24th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case. Thank you, Mr. Bartolacci.
Thank you, sir.
Court calls the case. People versus Keandre Allen.
Justice Fellows for the people.
Right, Your Honor. Morning, Your Honor. Rob J. Cohen, on behalf of Mr. Allen. Who state your name?
Keandre Allen.
Judge, this is a little unusual. Do we address bond first? Just to figure out which way we're going to go on this matter. It'd be greatly appreciated. Being the considerate judge of our.
Go ahead.
Judge, just very briefly, he has a circuit court matter with Judge Conlon, which he's on bond. He was out in a vehicle owned by his girlfriend. And again, not to argue the case, just very briefly, he was in a vehicle that had a gun in it. Gun is registered to the girlfriend. She was not in the car, but the person driving the car was allowed. He was the passenger. The car was pulled over at 1 or 2 a.m. claiming no lights were. The car did not have his lights on. They saw the gun. He's been charged. He has no bond on this matter.
On which matter?
On this matter.
Okay.
And what I'm asking, Your Honor, is for a PR bond or a reasonable bond. He's a sole breadwinner of the family. He's got a baby on the way. We're in circuit court with a PR bond. We're just asking that he be given a PR bond, and then I could get the discovery.
None of that makes any sense. The only thing I see is that he's got a personal recognizance of this case. I don't know why he would have no bond on this case.
What turns around and
that the circuit court case, which this case might be a violation of, he might get that, but on this case.
What's holding you then? This case. But you say you have a PR bond.
And they brought me back in front of the magistrate and told me that I have no bond the day I was supposed to be released. It didn't make any sense, bro.
On this case?
Yeah.
Mr. Oda, tell her.
What do you show? Yeah, I don't, on this one, that's what I've got in this file, is a PR on this case. But it would seem to me that what may have happened is the other case that he has, once they found out about this case, regardless of the facts of it, I'm not presuming he's guilty, but once they found out about it, that on that other case circuit, they would have denied his bond or done something.
Oh, Conlon Jr. gave me a PR bond on that one as well.
Judge Conlon just gave him a PR bond on that.
When was it?
Wednesday.
Last Wednesday. So I don't know what's holding.
All right, but when were you supposed to then got stopped brought back before that?
On Wednesday, I got a PR bond, and when they were getting ready to release me, they said CSO told me I had court for a warrant on Thursday for 11:30, and I went in front of the magistrate, and she said it was no bond. That was all right. Yeah.
She said it was no bond, so that means that must have happened in 14B or 15.
I'm being told it was 14B.
14B.
Okay, and 14B. What happened in 14B? That's what 14. Hold on. 14B has got to be what's holding him back. It is.
14B.
Probation violation.
We might have to get you. Okay. Judge Washington.
All right. So I'm not going to, unless you want me to, I'm not going to do anything with this bond here because he's got a PR. But
that's fine. Can we just adjourn this matter, and I will try and get to Judge Washington's court today. Deal with that.
Do you have a date on his 14th?
Wait, hold on a second.
So set for the 8th on that one. So
for the
Washington. You want me to set this for the 10th?
Please.
Probable cause conference will be set to 10th, 2026, 9 a.m.
September 8th.
On this case.
Judge Washington.
And we can see what Judge Washington does
I'll go on court and figure out who you say.
Dave,
10th. I know, part of the wall is causing a problem. And the whole room lit up.
You know, Judge.
Why? Because Torcio Feaster walked in. Yes. What?
Would be that between Mr. Feaster and we've discussed how considerate, kind you are. You're one of the most intelligent judges. I know you'd work through it.
Are you done?
Yeah.
I mean, for the day. Oh, joy. All right. Mr. Feaster, what have you been doing? Were you actually doing an exam?
Negotiating.
You weren't in an exam. Okay, so Ms. Akinruli didn't tell me the entire truth. No, Ms. Akinruli said you were in an exam and couldn't be here. I didn't realize you were just over there negotiating.
Just negotiate.
No, you don't. I don't accept it if you do. No. Court calls the case People versus Stefan Wainwright.
Pastor Feltus for the people and all. Seven.
And all set.
5 of which are abatements.
Okay. All right.
Yeah.
Assistant Public Defender Davi Lee before Mr. Wainwright in the 0198 and 0207 matters, and I believe we are yet to be appointed in the balance.
Yeah, because I don't know why these arraignments are before me, but
I'll have to look. I don't know. Well, the first 2,
the first 2 are.
these are the arraignments.
Okay. Okay, so Mr. Wainwright?